From the supplementary list, under heading for others, item 1, WPL 2165 of 2011.
Ali has been filed for substitute service notice.
Where is the Ali? ये रिकॉर्ड पे नहीं गया था, कल ही थे हुआ ना?
कल 5 मिनट से अभी सुबह में लगाया।
तो कल लोग चेक क्यों नहीं करवाए? नहीं समझ आता है, शाम तक चेक करना चाहिए ना। प्रभात खबर रामगढ़, one English and one Hindi. You will choose Telegraph. IU number 115545 of 2024. In WPL number 2165 of 2011. The counsel for the petitioner submits that. The notice sent to the respondent has returned unserved on the ground that the factory premises were found closed. It submits that this petition has been filed for substituted service of notice. It submits that the publication in the newspaper, the notice can be published in the newspaper Prabhat Khabar having circulation, Prabhat Khabar and Telegraph having circulation at Ramgarh. Considering the aforesaid submission, IU number 11545 of 2024 for substituted service of notice upon the respondent is hereby allowed. The petitioner is directed to furnish. The petitioner is directed to furnish draft copy of notice to be published in newspaper Prabhat Khabar and within bracket Hindi and Telegraph within bracket English. The edition which is having circulation at Ramgarh, Jharkhand. The draft notice in Hindi and English prepared and filed within the registry. The office by कब तक करने में हिंदी में भी करना है
छुट्टी के बाद
कोई बात नहीं by 15th of October
15th November
sorry हाँ by 15th of नहीं by 12th of November खुल गया 11 तारीख को
it will be 15th on 11th it is the
by 18th of November by 18th of November office is directed to do the needful and provide the notice to be published to the learned counsel for the petitioner by 4th of December for publication. Supplementary affidavit annexing the original newspaper be filed by the petitioner by 3rd of January. 3rd January हो जाएगा नहीं और ज़्यादा जनवरी का थोड़ा कैलेंडर चेक कर लेंगे 2nd वीक का फ्राइडे में और post this case in the supplementary cause list fixing the next date of hearing as जनवरी का 2nd वीक का फ्राइडे तक फाइल करेंगे एफिडेविट. डेट ऑफ अपीयरेंस विल बी मंडे no sorry Thursday in the next week. ठीक है? That's it. आइए disposed.
Under heading for admission, item 2, WPC 4254 of 2017.
Yes.
My lord, this matter may be disposed of pursuant to my lord's last order, 4/10/2024.
WPC number 4254 of 2017. The learned counsel for the parties are present. On the last date, when the case was taken up, it was submitted by the learned counsel appearing on behalf of the state that the petition has become infructuous in view of the affidavit dated 29/2024, annexing the Khatyan and Jamabandi, and it was for the petitioner to take appropriate steps for issuance of the receipt. The learned counsel for the petitioner and the matter was adjourned so that the learned counsel for the petitioner would go through the affidavit. Today, when the case is taken up, the learned counsel for the petitioner has submitted that in view of the affidavit dated 29/2024, the matter.
Paragraph may be noted, my lord.
Paragraph?
Paragraph, my lord, 8 or 7 onwards, 7 to 11, my lord.
Paragraph 7 to 11.
Yes.
This writ petition be disposed of, keeping it open to the petitioner to approach the respondent for issuance of letters.
My lord.
Considering counsel for the state has no objection to the pair made, considering the aforesaid submission. Paragraph number quote करने
मैं
का
कोट करके चलूँ क्योंकि उनका कहना है कि मेरा डिटर्मिनेशन ऑफ रेंट का था जिस प्लॉट का
कोई बात नहीं, उनका जो कहना है खाली बता
yes yes paragraph 7 my lord
Paragraph 7 to
11
7 to 11.
this is affidavit dated 24 copy has been served on 24/9/2024 का supplementary ये affidavit है
7 to 11.
24/9/2024
24/9.
Relevant is paragraph 9.
एक सेकंड देखने दीजिए. Paragraph 7 to 11 of the affidavit dated, ध्यान दीजिएगा quotation में, affidavit dated 24/9/2024 is quoted as under. Considering the aforesaid submission, this petition is disposed of as such, and it is open to the petitioner to approach the appropriate authority for issuance of the receipt. This हो गया?
video
Obligement.
Under heading for final hearing, item 4, WPL 2796 of 2001.
This petitioner. बताइए.
I'm on behalf of the
Who is for the petitioner?
Sri
Mr. A.K. Mehta. Where is he? Oh, perhaps he has not come to the court today. Yesterday he was saying that he is not. Anyways, you see, the whole purpose of listing this case is that they were running at the bottom of the list. Now we want to place it for final disposal such that it comes at the top of the list and the matter is ultimately disposed of. 2001 matter. 24 years has elapsed. And
my lord, in other cases, the persons have been regularized.
arising out of the same proceeding.
It's another proceeding in the same matter. In this case, 18 persons are there in present case.
You file an affidavit to that effect. You see, if you want similar order, then you have to file an affidavit to that effect. How do we exactly deal with your submission? Isn't it? Who is the learned amicus? For the respondents, you are the amicus.
My lord, I am for the respondent.
You have filed
Workers.
What
Respondent
column?
number 2.
respondent number 2. There is an amicus also in this case. Archana Kumari Singh. Who is she? I don't know her by name.
I also.
She was.
I'll
Archana
inform,
Kumari Singh.
I'll inform to Mr. Ramkumar Singh Mallar.
No, she is an amicus. Okay. Archana Kumar Singh, आप उनको खबर करें.
हाँ मुझे खबर.
ठीक है. Okay.
छुट्टी के बाद एक डेट फिक्स.
हाँ, इसीलिए फाइनल डिस्पोजल में रखेंगे.
Okay.
इसीलिए इसको
Okay.
हम जान रहे हैं आज इसमें डेट होना.
प्रॉब्लम.
That 2001 का मैटर
बहुत दिन से चला आ रहा है.
अब
सब
नहीं
लोगों का
चलेगा.
लाइफ जो है लगभग
अब
जो है
नहीं
किल पर.
चलेगा. जो होगा हो जाएगा.
Okay.
जो हमसे बन पड़ेगा हम कर लेंगे.
नहीं.
ठीक है.
Okay.
बताइए कब
और
करिएगा.
उसमें जो पुराने जो केसेस हैं उसमें वर्कर्स ने ये वो विदाउट सैलरी करके ये हुआ था. वो डिवीजन टैक्स अपना है हम लगाते हैं.
वो हम नहीं जानते हैं. आप जो भी लगाना है आप काइंडली लगा दीजिए. डिवीजन बेंच का ऑर्डर्स है, जुडिशियल ऑर्डर्स है.
जस्ट आई वांट टू प्लेस. और सिंगल बेंच का भी ऑर्डर है इसके बाद. और ऑनरेबल अपेक्स कोर्ट का भी जो है
आप इसको फोटोकॉपी करके देंगे.
हाँ हाँ.
अब दिखाइए जरा एपेक्स कोड का वाला कौन सा है. ये तीन चीज आप रिलाई कर रहे हैं. Nobody appears on behalf of the petitioner. From the records of this case, it appears that MS Archana Kumari Singh was appointed as amicus, but she is also not present. However, learned counsel for the concerned workman, Mr. नाम बताएं अपना. आप नाम बताइए अपना.
अजय कुमार सिंह.
Ajay Kumar Singh is present in the court. He submits that with respect to other similarly situated persons, certain orders have been passed by this court, and accordingly he relies upon the judgment passed in WPL number 1578 of 2010, decided on 22/6/2010. Semicolon. LPA number 426 of 2010, decided on 26th of July 2011. And judgment passed by Honorable Supreme Court in contempt petition within bracket C bracket close number 112 of 2010 in civil appeal number 3962 of 2006, decided on 10th of August 2010. He has furnished a copy of the aforesaid orders before this court. He submits that the matter is pending since 2001 and a date may be fixed for final disposal immediately after the Deepavali break. Post this case for final disposal on 18th of November 2020. Let a copy of this order be forwarded to Mr. A.K. Mehta, learned counsel for the petitioner, who is on record, and to the learned amicus, so that they may prepare themselves for the final disposal of this case. Record आया है इसमें? The records have already been received from the concerned court. The learned courtmaster is directed to retain the is directed to make sure that the records are made available to the counsel for the parties for perusal as and when a slip to that effect is furnished by the counsel. ठीक है, मंगा के दे देंगे ऑफिस. इसका फोटोकॉपी दे दीजिए।
Item 5 WPL 4739 of 2001.
This petition.
This case is also something that.
No, you want to argue it today or you want time? If you want time, you just let us know. Or if you want to argue, we are ready.
Yes, I'm ready to argue.
Okay.
Must have been received. It's a long
We do not know. If you want to argue, you argue.
Yes, I'm ready.
You argue.
I'm ready. Without SCR also I'm ready.
Then I will record that you have stated that LCR may not be called.
You can ask SCR to call. I'm ready, but SCR.
बताइए 2001 का मैटर में 2024 में LCR आप कॉल फॉर कर रहे हैं, कुछ तो जरा सोचिए।
I'm ready. We was getting 17P also payment.
So?
Till his retirement.
So what? 2001 में 17B कितना मिलता होगा इसको?
नहीं वो enhancement भी की हुआ है. He was on temporary basis. Below 1,000 he was getting. Only for
facts
7
are
months.
not clear, because
7
I was pursuant to this award, because I was reinstated, because I am working still retirement at work. 17
You have
2013 में enhancement के लिए pay हुआ है.
उसके बाद उसके पहले ही reinstated.
so you have attained the age of superannuation by
Because I
now.
have now Milords it's I have attained.
So it has become infructuous for all practical purposes.
Because that only to that extent, Milords, I'll submit Milords, because yesterday only I had a discussion with the client Milords.
Yes.
Let it be posted Milords in the opening or tomorrow or day after tomorrow.
Yes,
Milords, to
madam. You
submit.
also seek
I also
instruction.
seek instruction.
If he has worked, attained the age of superannuation, why do you need to fight unnecessarily? Right?
But only I was seeing the order in 2013, 70P was enhanced in the year 2020.
I'll
You
just
also
ver-
seek instructions. I'll just
Seek
record your submission.
Yes.
WPL number 4739 of 2001. The learned counsel for the parties are present. The learned counsel for the respondent worker on
20
instruction.
years of service leaving and continuous service since 2001.
नहीं वो तो गलत है 2013 में आप enhancement के लिए 70P का clear किए हैं. He is little bit confused.
ठीक है,
अभी
जो भी instruction है देखो.
हाँ.
The learned counsel appearing on behalf of the respondent has submitted that the respondent has worked in the
Look, pursuant to the award, Milords, he was reinstated. This instruction.
he submits that pursuant to the award, the respondent was reinstated and he continued to work, and as of now he has attained the age of superannuation.
This information I'll just verify. This superannuation.
And he needs to verify as to whether the respondent workman has attained the age of superannuation. He has also submitted that if that be so, the present case has become infructuous for all practical purposes. The counsel for the petitioner has submitted that she also needs to seek instruction and verify the facts stated by the learned counsel for the respondent workman, and submits that the matter may be posted after the Diwali break. Considering the aforesaid submissions, the matter is adjourned and is directed to be posted under the heading for final disposal on 12th of November
Milords.
in the supplementary cause list.
Make
Take
Milords
it.
subject to Milords 11th November will be.
11th is good?
11th.
With me? Okay, 11th November. Take. Next. Supplementary तो नहीं होगा, 11th
11th
November
एकदम
तो final
हाँ fresh
disposal.
filing में इसलिए तुरंत हो जाएगा.
Final disposal.
Final disposal. खुलेगा उसमें.
Item 6. Item 6 WPL 4039 of 2005.
हेडिंग्स
along
आपका
with
फाइनल
item
डिस्पोजल
7.
है यस मिनिमम वेजेस में भी आपको परेशानी लगे
इसमें हम खाली कोई एक डेट दे दिया जाए, फिक्स कर दिया जाए. Today I have called some discussion and I have asked them some information also. Any date I will argue on that.
मिनिमम वेजेस
Minimum wages or reinstatement भी है, passed by whether this comes under that act your lordship, that ex parte order was passed. Certain information just I have asked them. They have said कि हम लोग फाइल निकाल के वेरीफाई करके बता देंगे. कोई एक डेट दे दिया जाए, 11 खाली नहीं दिया जाए. Because 11th I don't know whether I will be in Ranchi or not.
सो अभी तो 11 तारीख का डेट फिक्स हुआ
वही सोच रहे थे.
नहीं तो ये जर्नल लेने के लिए यू आर नॉट श्योर
नहीं मेरे
2001 का मैटर हम
My-
आप लोग के सामने 11 को
my-
फिक्स
my
किया एंड यू आर
in-laws-
नॉट श्योर
my
वेदर यू आर
in-laws are doing something.
यू गिव मी सम अल्टरनेटिव डेट नो कॉल मिस्टर राहुल कुमार ऐसे नहीं होता है ना अगला डेट में इस तरह से
याद कर
जर्नल
रहे थे वही कि क्या डेट है, वो कुछ भी प्रवेश
हम नहीं जानते आप उनसे बुला के कोई और डेट ले लीजिए लेकिन इस तरह से मत करिए कि उस दिन जो है ओपनिंग डेट इज अ फुल वर्किंग डे Right.
कुछ आपको वो पटना that's why.
that is okay but when the date is being fixed in your presence then you should know whether you are available
I
or
was
not.
recalling that date.
So your case is that it is an ex parte order.
Ex parte order. I filed a revision also after 7-8 months. It was rejected. Limitation without any application of condonation of limitation, Your Lordship, that is 90 days. Without that, Your Lordship, it was
Mr.
condoned
Rahul
certain
Kumar,
things.
madam is not may not be available on 11. तो 14th को supplementary list जो है ना जरूर से
Minutes
pick
I
up
am
होगा.
always available. 14th, any day
14th
subject
in
to 14th.
supplementary cause list, right? At 2:15
Minutes.
to be taken up as first case और फिर खोलना है.
The small principle of minutes law is there.
आपके लिए स्मॉल होता है भैया हमारे लिए कोई चीज स्मॉल नहीं
So
है.
we will try to assist minutes.
हो सकता है infructuous हो गया हो तो I will be more than happy.
So only for some instruction and I will go through them.
Okay.
मेरे पास फाइल ही misplace हो गया था.
Respondent कौन है इसमें?
मनीष कुमार. Earlier
Where
date.
is he?
One case is appearing.
Yes,
और एक case में कहीं और है.
but he will assist.
नहीं ask him whether he will assist in both the cases. Next date में he will say I am there in only one case. ऐसा नहीं चलेगा. Call him. He has not come to the court.
I'm not saying him.
Please ask him.
I will got it.
Is it 2000?
5.
2005 कितना साल हो गया? 20 साल. अब बस 20 दिन का हमको पेशेंस नहीं है इस तरह के मैटर. आप उनको बुलाइए. Let we will adjourn it.
Yes.
But after recording that he is appearing in both the cases. Let him be here.
फाइल भी इसके पास एक ही था.
मैं वो आने दीजिए.
Just call him.
Call him by 11:30.
From the daily list under reading for final disposal, item 2, WPL 1798 of 2009.
Yes, petitioner.
The instant rate petition has been filed for quashing of the award. This is at annexure 4, page number 32. Certain कुछ facts बता रहे थे. The award starts.
Yes.
Lordship, in this case, Mr. Anup Mehta has to appear. Based on person ability is also to appear. Yes, we have a appeal not.
Will you be available tomorrow?
Day after tomorrow.
Yeah. He informed us that he is not available. The learned counsel for the parties are present. Counsel for the respondent submits that on account of personal difficulty, the arguing counsel Mr. A.K. Mehta is not available today. He submits that the matter may be posted day after tomorrow. Considering the submissions, this matter is directed to be posted day after tomorrow under the heading of final disposal to be taken up at the meeting.
Item 4 WPC 6511 of 2019.
Yes,
Today the counter is ready, my lord, and it is a delivery, my lord. Some delay has caused me to personal duty. I was not feeling well, and I was out of the station, and my client also. I have ready है, सॉल्व कर दिया काम.
अभी मिल गया
है, स्टेट को भी फाइल कर दिया.
आपको कुछ रिप्लाई फाइल करना है कि नहीं करना?
हम फाइल करके रिप्लेस करेंगे
WPC number 6511 of 2019. The learned counsel for the parties are present. Counsel for the respondent number
7.
7. दीजिए कहाँ है फाइल पे?
स्टेट को सब नहीं हुआ. स्टेट को सब.
स्टेट को सर्व नहीं किया.
नहीं, ये आज का डेट
Just a moment.
सर.
Is seeks permission to file counter affidavit in the present case during the course of hearing. Permission is accorded. Counsel for the petitioner prays for some time to respond to the supplementary counter affidavit.
On a date 3rd week of November.
Pose this case on
I'm returning it Rati on 25th.
27th of November. ये final disposal में है.
हाँ, yes, sir. जो आपको देंगे.
For final disposal to be taken up at
27 के या 29 के वाले को रिप्लाई देंगे.
29 Friday को नहीं हो सकता.
अच्छा.
27. The reply should be filed just. The reply to the counter affidavit should be filed by 14th of November.
By dinner will be.
Under heading for orders, item 5 WPL 6695 of 2016.
Ladies and kindly see order dated 29/20. The conducting for the petition has expired. So there was a notice was issued upon the petition.
They have appeared. Speed post. Speed post का कहाँ है इसका डिलीवरी रिपोर्ट?
आया नहीं लेट से इसमें ये शार्प नहीं.
The repeal number 6695 of 2016. As recorded in order dated 2/9/2024, the advocate on record has expired and notice was issued to the petitioner by speed post. As per office note, the notice was issued, but AD has not been received, and no fresh wakalatnama has been filed by the petitioner. Office is directed to issue notice to the petitioner through the concerned police station. Let the state of Jharkhand be made respondent number 2 in the present case only for the purposes of filing affidavit regarding service of notice. ये छोड़ दीजिए स्टेट ऑफ झारखंड का जरूरत नहीं. to the concerned police station. उसके बाद post this case on twelfth of November in the supplementary cause list, awaiting report of the concerned police station. Officer in charge of the concerned police station, who is directed to submit the report directly in the registry.
Item 6, WPL 699 of 2016.
Yes, petitioner.
At some point of time, it was by order number 2 dated 12/1/2017.
I
My
do
lords
not-
disappeared.
Who are you? I've never seen you earlier. Sorry?
Appearing for the first time.
For the first time? For seeking a recusal of the court. What's your name?
Ansley.
Yeah, but who is your senior?
Yes, ma'am.
Who is your senior?
Miss Amrita Singh.
Item 7, WPL 4579 of 2021.
Yes, madam.
Respondent number 7 may not deliver result or register cover and not its service report has not been received by the client.
Respond number 7. Who are you representing?
Representing respondent number 3, 4, 5 and 6.
7 से 10 में किया गया था नोटिस, 7 को रजिस्टर्ड कवर लौटा भी नहीं और सर्विस रिपोर्ट भी कुछ आया नहीं,
And what about 8, 9 and 10?
हो गया वैलिड सर में.
ये जो ये लोग ओवर राइटिंग करते हैं ना, ब्लैक पेन से लिखते हैं, फिर ब्लू पेन से लिखते हैं, फिर कटिंग करते हैं, उनको बोलिए अपना इनिशियल डेट के साथ लगाया था. गलत बात है ना? तब कैसे ऐसा परमिशन होता है? कटिंग करके कुछ भी लिख देते हैं. इनिशियल होना चाहिए, डेट होना चाहिए. WP, it is WPC or WPL?
WPL.
WPL number 4579 of 2021. As per office note, the notice has been validly served upon respond number 8 to 10. So far as respond number 7 is concerned, the registered cover, undelivered registered cover or AD has not been received. Respond number 7 is a formal party.
Fine. वैलिडिटी में भी लेबर डिपार्टमेंट को चला ही है.
You call Union of India. Who is called Union of India? Please call them. Why this Chief Labour Commissioner, Central Ministry of बुलाई जगह Union of India. नहीं, ऐसे लिख दीजिए. Counsel for the petitioner has submitted that यूनियन ऑफ इंडिया की तरफ से आप हैं? किसकी तरफ से हैं? Counsel for the petitioner has submitted that the notice has already been served upon respondent number 8 in the same office. Roughly mark. It's not in the same office. Who is for the petition? Oh, you are for the petition. कि as per the office note, notice has not been served upon respondent number 7. Petitioner is directed to take fresh steps for service of notice upon respondent number 7 through speed post. Office is directed to track speed post delivery and prepare appropriate office note with regard to service of notice. वो आ जाएगा उसमें हम लोग एक्सेप्ट
My lord, a date may be fixed.
कोई केस में बिना डेट के यहाँ नहीं होता है. कौन सा डेट आप चूज करें? You choose your date.
कुछ सप्ताह के बाद देते हैं.
Pose this case on 2 हफ्ता तक तो छुट्टी है. Pose this case on 12th of November 2024 in the supplementary office. Awaiting service to.
Under heading for admission, item 8, WPC 22 of 2012.
This is a very small request points.
Sorry?
Small request points. Personal request. Can it be next month, coming Monday or it's recovering from a bout of dengue, bit of physical discomfort.
You can have it after vacation also.
Anyway,
Is there any urgency in the matter?
no urgency as such.
Ex parte order.
It was not actually it arises out of mutation.
Monday.
It was
Ex
not.
parte.
It was not expected. It was not expected. I have an order sheet which shows they had it even. And subsequently they had not.
Is there any harm if they are heard? Is there any harm if they are heard and order is passed?
Oh, that is when the order of LRDC was
You
expired.
just, we are just figuring it out, yes.
No, since I am doing private respondent, they were noticed, they had appeared, subsequently their representation.
Let us see the order sheet. You just sit down, I'm just asking.
Yes, sure.
Where is the order sheet?
No, prior to that, the sheet would not sit.
I just want to see the order sheet. You have annexed the order sheet? Where is it?
In this petition there is order.
No, the proceeding sheet.
No, that is not. Which we are supposed to file. It is in process.
Who is for the state? The petitioner says that it's a an ex parte order. Is it an ex parte order? नहीं पता.
In this case, state has not filed.
There is a petition seeking amendment.
Yes, that's what I'm saying. Kindly see the order of the transport. They had annexed the on IEA, by IEA on authorization letter.
Oh, I remember this.
Yes,
This
that's
was
what-
heard by
that's-
me.
Yeah. Oh, last week you still heard.
इतना आसानी से निपटने वाला केस नहीं. Counsel for the parties are present. Counsel for the petitioner submits that the matter may be adjourned as he is not there. You want to respond to this IA?
It is already in process. We have served the copy. It's up.
At the request of the counsel for the petitioner, what date will suit you?
You can do it next week also. Hopefully recover by then.
Not
Or after
bad.
the holidays, any date after the holidays.
Pose this case on 19th of November.
Item 9, WPL 3188 of 2014.
In this case, I prefer for Mr. Mr. Edgar Senior and Mr. Edgar to argue, and he is in Delhi for medical treatment. It is against the award money. Refusal case.
On numerous occasions, either nobody appeared or it was adjourned on the ground of Mr. Narayan. Many dates are there.
I'm sorry to say, he has informed from Delhi.
You just tell us a date. If he does not come on that day, you argue the case. I will not adjourn it on his personal ground.
Any day after.
Any date, you just don't tell me any date. You choose a date. Calendar is before you. Because I will not give any adjournment on that day. So it's your choice. Choose a date. Record address.
Anything filed after 4 weeks, we will come back. I'm sorry, my lord.
No, he is under a medical condition.
Yes.
So, the learned counsel for the parties are present. M.S. Manjushri, advocate, submits that this matter has to be argued on by Mr. N.K. Naik, the senior advocate. The records reveal who is not well and therefore she seeks adjournment. The records of the case reveal that the matter was adjourned from time to time, either on account of absence of the counsel for the petitioner or on the ground of non-availability of Mr. N.K. Light, senior advocate. At this, the learned counsel submits that the matter may be posted after 4 weeks, and on that day, if Mr. N.K. Light is not available to argue the case, she would make alternative arrangement or argue the case herself. Okay? Counsel for the respondent has no objection. With the consent of the learned counsel for the parties, close this case under the heading of final disposal on 25th, on 2nd of December. More than 4 weeks ho gaya? 25th. On 2nd of December under the heading of final disposal.
Alright.
To be taken up back to 15.
Okay.
The records have already been received from the concerned court. The learned court master is directed to make the record available to the counsel appearing on behalf of the parties, as in when a slip is provided for such purpose. अगला डेट में record पढ़ने के लिए time मत मांगिए. Give a slip, you will get the record.
Item 10, WPL 1766 of 2015.
Yes, petitioner.
In this matter, pursuant to the last order, the lower court records were called for. The lower court records have come, but perhaps there is an anomaly. The presiding officer has sent the wrong lower court records. Because Annexure 6 is under challenge. We have challenged the legality and the validity of the reference, terms of the reference. That is at page number 93. And what has happened, instead of sending the LCR of reference case number 1 of 2015, the records have come of reference case number 1 of 13.
Is there any error in the order?
No, there is no error. Order is only call for the scanned copy of the lower court records.
One of 13 has come.
1 of 13 has come. It needs to be called for 1 of 15.
The learned counsel for the parties are present. The learned counsel for the petitioner submits that the connected records of the present case is when the notification is under challenge, then where is the question of calling for any record?
Your Lordship, the notification was under challenge when this rate petition was filed in the year 2015.
Yes.
Perhaps during the pendency of this rate petition, that notification got terminated into registration of a reference case. That reference case got renumbered as reference case number 1 of 15. And now before proceeding further, it needs to be ascertained whether the reference case 1 of 15 is still pending or it has been disposed of, so that we could proceed further.
This case has become infructuous.
आ जाए एक बार LCR तो
नहीं LCR का क्या है, ये केस तो infructuous हो गया होगा by now. You see the court must have entered into reference.
एक बार आ जाए
नहीं हम अभी पता करते हैं, ऐसे इस तरह से ना केस को एडजर्न आपको कभी मना किए हैं टाइम है ना,
इसमें
you have challenged the notification of reference. Now it is 2015 reference, it must have been decided by now.
लॉर्डशिप वही तो जानना है हमको भी
हम लोग पता करें,
कंफर्म
हम
से
लोग
इंफॉर्मेशन रिपोर्टिंग मंगा लिया.
And you just see page number annexure 3 page number 57. You just see page number 57. देखिए क्या नंबर लिखा
ये रेफरेंस केस 1 ऑफ 30 ये हुआ क्या, सेम कॉज ऑफ एक्शन के लिए मल्टीपल लिटिगेशंस हो रही थी कंपनी के बीच में. जार्डिन हेंडरसन, आई एम रिप्रेजेंटिंग मिसेस जार्डिन हेंडरसन लिमिटेड. तो जो सब्सिक्वेंट डॉक्यूमेंट्स था, all relevant documents which were essential to decide the controversy, उसमें हम लोग ने ये preliminary objection file किया था and we had marked this document as annexure. एक रिपोर्ट मंगा लिया जाए, things should be clear. Presiding officer से
counter affidavit has been filed by the respondent union. The terms of reference is under challenge. ये जो अगर ये डिसाइड हो गया होगा तब तो केस इनफ्रक्टिव हो गया होगा.
हमको
अभी सेकंड हाफ में आइए पता करना है, ठीक है. इसका जरा पता करिए तो रेफरेंस केस नंबर 1 ऑफ 2015 राइट.
Yes.
लेबर कोड धनबाद यही है.
जी
इंडस्ट्रियल ट्रिब्यूनल नंबर 1 2 कुछ नहीं है, लेबर कोड धनबाद. जरा बताइए इसका स्टेटस. आप लोग को स्टेटस पता नहीं चलता है क्या? कांटेक्ट की क्या जरूरत है, कंप्यूटर से भी कांटेक्ट नहीं होता है क्या आपका? अभी पता करिए रजिस्ट्री को बोलिए. ऐसा तो नहीं हो सकता. ई कोर्ट में आपको ये नहीं मिले तब तो बहुत मुश्किल हो जाएगा. We will be in deep trouble. And if that is so, then something is required to be done. स्टेटस तो बताएगा ना, पेंडिंग है, डिस्पोजल है, केस ही नहीं है तो नहीं हो सकता. तो आज 2:15 बजे आइए, हम पता करके बताएंगे. आप क्या बोलना चाह रहे थे? डिस्ट्रिक्ट कोर्ट्स में ऑर्डर अपलोड नहीं हो रहे.
डिस्ट्रिक्ट कोर्ट्स का ई कोर्ट्स वेबसाइट पर डिस्ट्रिक्ट कोर्ट्स का डाटा, सिविल कोर्ट्स का शो होता है, लेकिन लेबर कोर्ट्स और इंडस्ट्रियल ट्राइब्यूनल, एजुकेशन ट्राइब्यूनल ये सब का नहीं कोर्ट्स बना.
हम लोग पता कर लीजिए. हाँ पास ओवर एक
Passover case from supply list.
2 केस है. पहला जो केस है उसका फाइल मेरे पास नहीं है, बट आई एम रेडी टू अपीयर. हमको कॉपी मिल जाएगा तो
कॉपी यही देंगे ना.
इनके पास तो खुद ही हमसे मांग रहे थे, तो सेकंड केस का इनको हम दिए हैं कॉपी.
फर्स्ट केस का पिटीशन हम इनको दे सकते हैं, रिकॉर्ड पूरा मेरे पास नहीं है. लेकिन पिटीशन जो है उसमें जो एनेक्शन है उतना हम पोर्टल से निकालें तो वो हम इनको दे
हमको
सकते
अगर
हैं.
दिलवा दिया था मैंने तो अच्छा होता.
रिकॉर्ड मेरे पास
ही poor man, he is unable to come, my lord.
He is a poor man. Petitioner is also poor.
नहीं, petitioner is not poor.
So
इनके
you are
पास
equally poor.
है ही नहीं इनका काम.
आप poor रहेंगे तो वो poor बन ही जाएंगे.
नहीं इनके पास है ही नहीं इनका काम.
Employee अगर poor रहेगा तो employer poor हो ही जाएगा. Right? It's a poverty of the employer if their employee is poor. क्या बोलना है बताइए.
ये क्लब है मैडम. So
Club
leadership, it's a club. It's not management. And it's a dispute.
Club is a poor. 2%.
क्लब में तो थोड़ा कंट्रीब्यूट करके क्लब चलता है. Like it is not a profit.
ये वाला
आपका म्यूचुअलिटी का जो डॉक्ट्रिन है ना, इसने बहुत पेच.
ये वाला माय लॉर्ड्स दिलवा दिया था तो
हम आपको दिला देंगे, लेकिन अगला डेट में टाइम
नहीं
देंगे.
I have argued so many times. I will not accept it. खाली से रिकॉर्ड नहीं था मेरे पास.
इसमें भी LCR
LCR आपको किस लिए चाहिए? 2000 कब से चल रहा है केस?
इसमें LCR है, जरूरत नहीं।
2005 से चल रहा है, अभी तक LCR का तो होश नहीं आया आपको। एडजर्नमेंट के लिए LCR मत मंगाइए, ठीक है? The learned counsel for the parties are present. आपको भी रिकॉर्ड चाहिए? आपको भी ये रिट का रिकॉर्ड है आपके पास?
हाँ, रिट का रिकॉर्ड
दोनों?
हाँ।
तो फिर आप इनको क्यों नहीं दे रहे?
अरे भाई आपने सर तो क्यों नहीं दिया, फिर क्यों बोल रहे हैं? आप बोले कि नहीं है, याद कीजिए।
नहीं था ना, तो
प्रोवाइड करिए।
वो निकलवाया।
कौन सा रिकॉर्ड आपको प्रोवाइड करना है?
पहला केस का 4039/235
4039. Mr. Manish Kumar, advocate, submits that though he has not filed wakalatnama in WPL number 4039 of 2005, but he has received instructions to appear in this case. He has further submitted that a copy of the writ records be provided to him by the petitioner. He has submitted that he shall not seek adjournment on the next day and matter be posted post Deepavali break. Counsel for the petitioner undertakes to serve a copy of the entire records of WPL number 4039 of 2005 to Mr. Manish Kumar, advocate, by day after tomorrow. With the consent of the learned counsel for the parties, pose this case under the heading for final disposal on (27th of November).
Yes.
27th of November, 2024. To be taken up at shops and establishment है.
ये मिनिमम वेज एक्ट का मैटर है, वाला
एक शॉप्स एंड एस्टैब्लिशमेंट।
हाँ ठीक है,
एक मिनिमम वेजेस। आप लोग मिनिमम वेजेस भी नहीं देंगे
हाँ
क्लब में?
दूसरे वाला मिनिमम वेज का है,
मिनिमम वेजेस इज अ पार्ट टाइम।
उसमें 10 बार
थोड़ा सोच के बताइए, क्लब में आप मिनिमम वेजेस नहीं देते, पार्ट टाइम ही होगा ना क्लब में, सुबह से लेकर रात तक क्या ही काम रहता है। थोड़ा सा अपना बोनाफाइड दिखाइए।
हम कुछ ऑफर किए थे,
इनको नहीं पसंद है आपको, उनको ऑफर नहीं पसंद।
हाँ हम ऑफर किए थे तो ये उस पर एग्री नहीं, हम बोले कि 1 मिनट का रास्ता निकालते हैं, हम इतना पेमेंट कर देते हैं, तो ये बोले नहीं हमको इसका इतना देना चाहिए।
5 का केस है, मतलब मिनिमम वेज का डिफरेंस 5000 है, कहीं 5000 ले ली।
5 नहीं गलत बात नहीं बोली, 5000 नहीं बोले थे हम, 30,000 इनिशियली हम 30,000 ऑफर किए थे।
अब तैयार है 30,000 के लिए? 6 टाइम्स हो गया।
हम एक बार उससे पूछ लेते हैं, मतलब हमको कोई आपत्ति नहीं है।
फर्स्ट इंस्टेंस हम 30,000 ऑफर किए थे।
अभी भी ऑफर है।
हाँ ठीक है, आई एग्री, अभी होंगे, हम मानते हैं, यस
आप रेडी? ठीक है,
अब तो रिकॉर्डेड
मिनिमम वेजेस जैसा चीज में आप लोग इसको
नहीं, मतलब हम तो एकदम
आप काम कर रहे हैं कि नहीं कर रहे?
नहीं, वो तो कभी
हटा
नहीं,
दिया।
दूसरा केस नहीं होगा
जी, और शॉप्स एंड एस्टैब्लिशमेंट का मैटर।
हाँ उसी में हटाया, वो उसी का केस, उसका फाइल नहीं मेरे पास, बट ही इज नॉट वर्किंग, आई एम श्योर अबाउट।
लेबर कमीशन ऑर्डर
उसको रिमूव कर दिया, जब ही डिमांडेड मिनिमम है तो नहीं रिमूव सकता, यूज पर रिकॉर्ड।
Item 11 WPC
इंस्ट्रक्शन नहीं लेंगे अगर कुछ नहीं
आप
हाँ
कैसे
हाँ
ही
ले
ले
लेंगे, बात तो हो गई, 30,000 बोलिए, कुछ नहीं ना।
देखिए मिस्टर मनीष कुमार अगर कुछ बोलते हैं ना, रिकॉर्ड पे अगर नहीं भी हम लिखेंगे तो ही विल अबाइड बाय इट, इतना हमको कॉन्फिडेंस है।
Item 11 WPC 4456 of 2015.
Yes, petitioner.
Rent is which was granted up to 1994-95 has been stopped by the authority. The now that proceeding for cancellation of judgment of my vendor was initiated, and that proceeding ultimately order was passed against her, but it was passed by the writ court and affirmed the LPA. They also preferred some basic to the Supreme Court. Withdrawing for filing a review. Review was filed, that was also decided against the movie of Supreme Court, and we debated to file another review that was noted in the order dated 18/7/24.
Who filed the petition?
State.
Writ petition was filed by the
Writ
state.
petition, no, review petition filed by the states. Writ petition
Who filed
by-
the writ petition?
I filed the.
You were the writ
Yes.
petitioner.
One Kalpana Pandey is filed by the state, not this.
And who is
petition.
Subhash Kumar Jain?
Yes, Subhash Kumar Jain is a purchaser from Kalpana Pandey. Fraction of land.
Which is the order of the writ court? Where is the order of the writ court?
Writ court. Yes. Section 3 at page 40.
Yes?
Malas,
Yeah, Bolo.
malas, since in a similar matter I have appeared malas, in which malas perhaps there was
Similar matter.
Malas-
In this
malas-
particular case, there is a history of litigation.
malas, that
So
is what
don't try to intermingle with similar matter.
no malas, I am actually conceding on that point malas, that in other matters malas, rent receipt has been issued malas, and therefore malas, I need malas adjournment to malas verify the same malas, that whether this petitioner is also
So
malas,
if not issued, it will be issued. Simple.
because malas,
I
I'm
can
aware
just
of this fact
observe.
malas.
I can just observe that issuance of rent receipt does not create any right, title, interest, etc. in favor of either parties
And that is
or
subject to
any
the
claimant. That much we can observe.
and that is subject to the outcome of malas, that civil review which was filed by the state malas.
Civil review
Malas,
pending.
malas,
Where is that?
malas, civil review 99 of 2019 malas.
Where is it?
That is
Look at the civil review. 99 of
2019 malas.
2019. इसका status बताइए. Is it assigned to this bench?
It is pending with defect till date. As per my information from the
Just a
website.
Civil review 99 of 2019.
Pending उठाना out of list है.
It may be disposed of with the direction malas, that subject to the outcome of that civil review malas, that till then malas.
We can observe one thing, that so far as this writ petition is concerned, he has got nothing to say because the orders have attained finality. But everything will be subject to the final outcome of the civil review application. That should be sufficient. WPC number 4456 of 2015. Heard the learned counsel for the parties. This writ petition has been filed. Civil review किसका फाइल किया? Writ order का.
नहीं LPA का है, against LPA. Division bench.
Review is against division bench order.
Yes, division bench.
Against
You have noted on the order dated 18/7/24.
Pending a defective.
as per order dated 18/7/2024. The matter was adjourned and was directed to be placed today or after disposal of civil review number 99 of 2019 in favor is earlier. When the matter is taken up today, it has been reported that civil review number 99 of 2019 is pending before Honorable Division Bench. And the last order is dated 29/11/2022. It was submitted by the State of Jharkhand, who is the petitioner in civil review number 99 of 2019, that the defect number 1 in the civil review application has been removed and the remaining defects will be removed in the course of the day. The office was to verify the same and take up accordingly. However, the counsel for the state is not in a position to give the current status of civil review number 99 of 2019. 2022 से out of list चल रहा है, right? The order dated 29/11/2024 has been placed by the learned court master for perusal of this court. It has been passed in civil review number 99 of 2019. ये writ petition इसलिए नहीं disposal कर सकते हैं. You never know, the LPA court might remand the matter. Possible?
Any possibilities there?
Any possibilities there. So therefore we will not dispose of this matter.
Then placed after disposal of.
Let this writ petition be posted on 3rd of January 25. The counsel for the state is directed to apprise this court regarding the status of civil review number 99 of 2019 at the next date. So ये मत ऐसे.
Sorry for the interruption, Your Lordship. Item number 4000 थोड़ा सा हमको पहुंचने में लेट
कोई बात नहीं. क्या किए?
एक टाइम
टाइम हो गया है तो उसमें क्या कुछ कर नहीं सकते हैं ना. डेट हो ही गया है तो अगला डेट में करेंगे.
कोऑपरेटिव सोसाइटी वाला मैटर
कोई बात
जो उसमें मांगा गया था कि 28/5/2016 के बाद कितना डेट है. देयर आर सो मेनी सेवरल डेट्स उसका हम बना के सब फाइल करेंगे.
We do not do. You come on the next date.
Item 12 WPC 3666 of 2016.
Yes, petitioner.
Lordship, I pray that this case may be taken up after 1 week.
देखिए अब इतना भी होगा ना, सब में लोग टाइम मांगने वाले हैं तो हम क्या काम करेंगे.
नहीं, ये इसमें जो डिफिकल्टी ये है कि direction was given to file supplementary counter affidavit, and Lordship, supplementary counter affidavit has been filed on 16/10/2024. Therefore, Lordship, I am praying only 1 week time, Lordship.
The learned counsel for the parties are present. Counsel for the petitioner submits that supplementary counter affidavit has been filed on 16/10/2024 and he prays for time to file a reply.
Lordship.
He submits that the matter be posted after the Babadi prayer. Post this case on 14th of November 2024. The reply to the supplementary counter affidavit be filed latest by 12th of November.
12th, Lordship.
Item 13 WPC 5000 of 2016.
Very humbly, I'm praying for hosting this after the Diwali holidays. Voluminous records will be launched. I'll just make a compilation of everything in this matter. Because there are multiple counter affidavits and supplementary affidavits that have been filed and rejoinders as well. Therefore, I'm praying only one indulgence will be. What is it? Kindly see the nature of prayer. For consideration of a representation.
Yes.
But on the last day.
So whatever be the volume of the brief, it makes no difference because that is your prayer.
On the last day, there was an interlocutory application that was also allowed because there are the respondents who have come stating that they also have an interest in this.
So therefore, it has to be referred to civil court. So,
but the respondent state has brought on record saying that the land itself that I'm claiming for does not exist because the khata number is
we do not know whether the land exists, whether you have a title, whatever it is, everything will be adjudicated only by civil court. We can't decide whether such and such plot is existing or not existing, or where it is existing.
Only place for one indulgence.
No. This is absolutely this is the relief prayed and that is all. Yes, who is for this? Yes, you are for NHI?
Yes.
What is it?
Also, after vesting of the land, the petitioner has filed the representation for the payment of compensations.
After vesting?
Yes. Treating the land as a realty land. And the land is notified as GM land.
Madam, you just tell us. What is the remedy for that?
3H4,
3H4 is the only remedy?
Yes.
Right? Really national idea.
It may be passed over for a few cases. Maximum assessment.
This we have interpreted also,
Yes.
3H4, and we have held that any dispute has to be referred to in terms of, even if there are private disputes, whatever it is. Where is that order, madam? Have you got that? We are just passing it over, get that order also and give it to her also.
Yes.
Whatever be the rival claim, whatever be it, this is how it has to be. Don't try to scare me by volumes, right? It makes no difference.
My only intention was that since there were multiple affidavits, I'll prepare a compilation of even those.
Volumes, when the volume is more, the merit is less. In number of matters. It will be taken up at 1 o'clock.
Item 14 WPC 6962 of 2016.
Possible for few cases.
What is it?
This is a cancellation that search and seizure was carried out at the business premises, factory premises of the petitioner, wherein the license of the petitioner's proprietary firm has been cancelled.
So, the license period has expired?
This license was effective till 2016 itself.
It has expired?
Yes, because it has expired. As also the factory premises of the petitioner has been sealed, and it is sealed till date.
This is excise license?
It's
So,
few cases possible. My senior will come.
you have an appellate remedy also.
The license has been cancelled without giving an opportunity of being heard to me. The same day license was cancelled, the same day prosecution was a complaint was filed. And in
Yes,
the
what do you
complaint-
say? You cancelled the license at the drop of hat?
Your Lordship, as per the counter affidavit, Your Lordship, page number 20 of my counter affidavit, Your Lordship. Your Lordship, the petitioner company's so-called notice were issued, Your Lordship, on dated 11/6/2016 and asking the petitioner to appear in person and submitted his so-called, but he did not appear, Your Lordship. That's why Your Lordship, on the further, Your Lordship, the Matter was again taken up on 21/6/2016 and the matter was taken up by the Assistant Commissioner Ranchi and the all materials were placed before the DC on 22/6/2016. Thereafter the DC has cancelled.
The date of hearing on 21/6/16 was intimated to the petitioner.
Yes, Your Lordship. But it did not.
From where do you see?
Your Lordship, paragraph 15, page number 14.
Let us senior come. देखिए ये पूरा का पूरा फाइल लिखा हुआ है, ठीक है? पैराग्राफ नंबर
15.
You had asked him to appear on 26/2016. Where is the date of hearing on 21/6/16? You get that? This is Annexure C.
Yes, Your Lordship, page number 37.
Can you show me the date of hearing here? Where is it mentioned? What is the date of hearing? तीन दिन के अंदर अपना स्पष्टीकरण दीजिए, right? What is the date fixed? What is the time fixed? And you say in your affidavit that it was fixed on 26. From where do you get 26? कहाँ से लाए? No, what instruction? No. Once I put a question to you, you are. No, you read it. You prepare yourself. इसका इतना ही बहुत है. इससे ज़्यादा कुछ करने का जरूरत नहीं. बैठ जाइए.
This old court was a better court.
Old court was better.
We did not have to run so much.
ऐसा कोई रन करने की जरूरत नहीं है. ऐसा कोई आपको बिना सुने ऑर्डर
करता है.
अब देखिए आपके बिना भी ऑर्डर हो जाता, आपकी जूनियर का नाम अपीयर कर जाता, तो आपको क्या प्रॉब्लम है? हाँ, you don't want your juniors to flourish.
It's absolutely
so
not.
Therefore, you should have more juniors so that you may have to run less. Pay them well.
I understand.
Pay them well. I know you must have been paying. बताइए. पढ़ लीजिए. This is the only point. No hearing.
Additionally, we have filed a IA petition.
For what?
Because what had happened, when the writ petition was filed, we had challenged single action that you have not issued us a notice, did not give us opportunity of hearing, you cancelled the license. Now, what they had done, they had filed a simultaneous criminal prosecution. And since my factory premises was under seal, so I could not have done anything. Now, after 8 years of their deep slumber, they wake up one fine morning and what they do is they issue us a notice that all the materials which is lying, we are going to destroy it. We tell them that your allegation is that the factory, which is a closed factory adjacent to it, some spurious liquor has been found. There is no dispute that I was a valid manufacturer.
You see, we will not expand the scope of the writ petition.
There is a reason. There is a reason to it why I am saying so. Criminal proceedings have already been dismissed against them.
Very good. So
now, my factory premises is sealed since 2016.
Sealed in a criminal case or in this
No,
case?
in this case.
So therefore,
so now, I have been writing to them.
Please, you won't have to write anymore. You will have an opportunity to file your show cause, and then they will hear the matter.
Only one minute. Because further development which has taken place is
Now they want to alienate my property to a third party on a
They
basis
will
of a
not be able to
representation.
do anything. You just tell me when you want your hearing.
Minutes, whenever, earliest the
So
better.
that is why I'm putting
Earliest the
question.
better, minutes, post Diwali, any day, minutes.
Yes, madam. That should be sufficient. This is the only reply you have given?
Yes, Your Worship.
Minutes, paragraph, they have said might have, they have used the word might have.
Where is it?
Minutes, paragraph 20 of their counter affidavit. This is the only thing which they have said. This is all they say, minutes, in the entire counter, nothing else.
You see, what I am finding is that in para 11 they say
Yes, minutes.
that this letter was issued asking you to appear in person on 26/2016.
Correct, minutes.
But that date is not there in
That
Annexure
date
C.
is not there. That apart, minutes, for a proper service of notice, there is no document they have appended.
आप अपने पूरा नीचे देखिए ना 17/6/2006 का 2016 का डेट लिखा हुआ है NHS.
They have said so.
No, they have not said so that it was served on such and such date
Yes.
and therefore on 20th. That is not mentioned.
That is not mentioned.
And 3 days is absolutely insufficient to respect. These two things. कब hearing करेंगे और कौन hearing करेंगे? Which authority? No, which authority will give them hearing?
Your Worship, Excise
Minutes, Excise Commissioner.
Respondent number?
Minutes, the respondent number is, I'll just. Is the respondent number 2, minutes. The respondent number 2.
देखिए WPC number 6962 of 2016. Heard the learned counsel for the parties. This petition has been filed for the following relief. The learned counsel appearing on behalf of the petitioner has submitted that the excise license granted to the petitioner has been cancelled in gross violation of principles of natural justice, inasmuch as the impugned order has been passed without hearing the petitioner. The learned counsel has also submitted that during the pendency of this case, a criminal prosecution was also launched against the petitioner arising out of the
Same search and seizure.
the allegation made against the petitioner. But the criminal prosecution has been quashed.
Minutes, it has been dismissed as against them.
The criminal case has been dismissed as against
The Excise Department.
the Excise Department
On 7/12/2019.
on 7/12/2019 by the concerned court.
Yes.
The learned counsel has also submitted that the entire factory premises of the petitioner is under seizure of the respondent. And the petitioner has suffered on account of ex parte order passed against the petitioner without granting an opportunity of hearing. The learned counsel appearing on behalf of the state has referred to the counter affidavit and has submitted that by letter number 1201 dated 11/6/2016, the petitioner was asked to appear in person and submit his show cause on 20/6/2016, but the petitioner did not turn up. However, from perusal of Annexure C, and she has submitted that the notice has been annexed as Annexure C to the counter affidavit. She has also submitted that The matter was again taken up on 21/6/2016, and all the materials were placed before the Deputy Commissioner. By the Deputy Commissioner, was placed by the Deputy Commissioner on 22/6/2016. And thereafter the क्या attachment है? Annexure D क्या है? What is an annexure D?
That was the warrant of arrest which was issued against the petitioner. Petitioner was taken into custody, and he was granted bail by this honorable court. So this is the warrant of arrest which has been annexed by them.
But how do we know what is it?
It's mentioned at page 39 on the top. Warrant of arrest against Dinesh Narula, the petition. On the top it is mentioned.
The Learned Counsel has also submitted that it was decided to inform that has been stated in paragraph 17 that it was decided to inform the petitioner at his permanent address through registered cover and email. But the registered post returned with postal note that the addressee has refused to receive, and the email was delivered. She has referred to Annexure D to the contract.
May I just clarify? This Annexure D is a warrant.
Please hold on. This is what is written in the contract. जो है तो उसको
They have said.
to improve.
They have said.
So.
They have said. But it is a warrant of arrest which
You
they
just,
sent to Chandigarh.
I will record your
Yes.
submission. Don't worry. She has also submitted that a statement has been made in the counter affidavit that the writ petitioner left India on 15/6/2016 for Australia to meet his doctor and came back on 11/7/2016, and as such he did not receive the show cause notice. ये तो आप खुद ही बोल रहे हैं. Although in the writ petition, the petitioner has stated that he was available in Ranchi till 10th of June 2016. It has been asserted in the counter affidavit that the aforesaid indicates that the petitioner was present on 11/6/2016 and he might have flown to Australia to avoid arrest. What is letter dated 1202? There is no averment regarding letter number 1202. In the counter affidavit, a memo number 1202 dated 11/6/2016 has been annexed, fixing the date as 26/2016 for hearing. However, the said document has no receiving from the petitioner. Anna?
Yes,
Right?
page 38.
The learned counsel has, should I record that an opportunity of hearing can be granted? The learned counsel appearing on behalf of the state has submitted that an opportunity of hearing can be granted to the petitioner considering the facts and circumstances of this case, but the dismissal of the complaint case filed by the state against the petitioner has no bearing in this case. The seizure has taken place pursuant to the impugned action, pursuant to the action impugned in the present case. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, and going through the prayer made in the petition, the sole grievance of the petitioner is that his license has been cancelled in gross violation of principles of natural justice, and inasmuch as without granting opportunity of hearing to the petitioner. As per the counter affidavit, a letter number 1201 dated 11/6/2016 was issued to the petitioner asking the petitioner to appear and show cause on 20/6/2016, but the perusal of letter as contained in Annex C to the counter affidavit, which is memo number 1201 dated 11/6/2016, no such date has been fixed in the said letter. Upon a query of this court to the learned counsel for the state, she has not been able to show the date fixed for hearing as 26/2016 on the memo number 1201 dated 11/6/2016. The said letter also does not show the receipt by the petitioner, and in the counter affidavit, nothing has been mentioned as to when and to whom the said letter number 1201 dated 11/6/2016 was served. The counter affidavit also revealed in the counter affidavit another letter being memo number 1202 of dated 11/6/2016 has been annexed, wherein the date of hearing has been fixed as 26/2016, but the same letter also does not, the same letter has no receiving of the petitioner, and in the counter affidavit, no averment has been made with regard to memo number 1202 dated 11/6/2016, much less any averment regarding receipt of the same. It further appears from the counter affidavit that the respondents have, this court finds that the counsel, the state has not been able to demonstrate due opportunity of hearing to the petitioner through the counter affidavit, and therefore the impugned order is apparently an ex parte order and has been passed in gross violation of principles of natural justice. Without granting an opportunity of hearing to the petitioner. Consequently, the impugned order calls for interference on this sole point, and the matter is related to the respondent number.
Minutes. Respondent number, the order was passed by respondent number 3 minutes. As would be evident from page 60, the order has been passed by Sahayak Ayukt Utpad
To the respondent number 3.
3.
Is commissioner can also hear it?
Yes, my lord. He is the appropriate authority to my understanding.
And the matter is remitted to respondent number 2 for granting an opportunity of hearing to the petitioner and pass appropriate order in accordance with law. It will be open to respondent number 2 either to hear the matter himself or appoint appropriate assistant commissioner to hear the petitioner and dispose of the matter.
It's within a time frame.
Yes, every time frame will be there. After date of appearance will also be there.
Well, let's fix a date, will appear.
I invariably
Only
demand
one
as
thing.
tarah se nahi hota hai.
Well, it's only one thing I must
So how
point
much
out.
time will you need to file your reply?
Well, it's 3 weeks.
The petitioner is directed to appear before respondent number 2 on 12th November.
12th November.
On 12th of November 2024, along with a copy of the writ records and a copy of this order and also his show cause reply. The show cause has now been served to the petitioner through the contract.
But it's only one thing I must point out. Since I had filed a IA petition 8925 of 2024, if my lords would only see for a moment for a reason, I am saying.
Please hold on, just a moment. The respondent number 2 shall do the needful in terms of the aforesaid direction, and after giving an opportunity of hearing to the petitioner and considering the materials to be placed by the petitioner on record to the show cause reply, pass a reasoned order and reasoned order by 3rd of December.
3rd of
By
December.
3rd of December, and communicate the same to the petitioner through his email ID to be provided by the petitioner in the representation itself. For the aforesaid purpose, the impugned order is set aside and the authority shall pass appropriate order without being influenced by any observation and finding in the
Now, with the IA petition, I have filed 8925 of 2024. There was a prayer which I had made. My lords may dispose it of that it will be open for the respondents to decide that issue as well.
What was the prayer?
The prayer was for to unseal the premises along with non-spurious goods so that I can restart my factory premises.
At this, counsel for the petitioner has submitted that a prayer has been made in this petition through interlocutory
Yes, my lords. IA 8925.
Being IA number
8925 at page 7 is the prayer note.
8925. जैसा आपका शोकास का हाल है वैसे मेरे रिकॉर्ड करना है.
It's just been filed recently.
I don't find it here.
We have filed it recently. It was filed 20th of August 2024.
ऊपर नीचे कहीं भी लगा देते हैं क्या?
At page 7 is the prayer note.
Wherein a prayer has been made seeking a direction upon the respondents to unseal and hand over the possession of the licensed factory premises to the petitioner along with non-spurious goods lying in the factory. Considering the nature of relief through the interlocutory application, it is sufficient to observe that in case the matter is ultimately decided in favor of the petitioner, there may not be any reason to continue with the sealing of the premises.
Much correct.
If there is no other legal impediment in that regard. The aforesaid relief would essentially fall, no legal impediment in that regard. The respondent number 2 or his authorized officer shall also consider the aforesaid relief of the petitioner if such prayer is made in their show cause reply and pass appropriate order in this respect also.
Much.
इसको जरा ठीक से बांधिए भाई.
This IA has to be disposed of.
Yes. Pending IA closed.
Much.
The petition is disposed of on their proceed limited issue.
Item 15 WBC 7030 of 2017.
Who is for the petitioner? What is your counter affidavit? Yes, what is your counter affidavit? Why have you sealed their premises?
We have stated that it is an encroached land and the shop in question does not belong to the petitioner.
So,
Ladyship, it is encroached and it neither belongs to the petitioner nor it belongs
was he in possession of the property?
That is also disputed, Your Ladyship. Intervention application has also been filed by the person who is claiming that the land is in his possession.
State has become instrumental in removing one person and inducting another person. State is being used for that purpose. No, they will not permit this. You will evict the petitioner and then one intervener will come and claim that it is my property and court will pass an order to release the property in favor of the intervener. So,
and perhaps the prayer is for removal of the lock from the premises. Maybe it has been removed. That is why the petitioner took time on the last occasion to verify the presence.
you can't do this, madam. They will not permit this. You see, show cause was also issued to the petitioner. Isn't it? 144 proceeding was also there. There were two parties fighting and you evict them. Under what procedure? Yes, under what procedure?
The issue was the prayer of the petitioner only to convert the proceedings into 1.5 CR.
Maybe, but can you evict a person? What is the prayer?
Prayer is for removal of the law that has been put in the
Yes.
premises.
So did he ask you to put a lock?
The issue, but whether he was actually performing his, he was actually carrying on business from that premises is disputed, Your Ladyship.
You see, for 144, what is the nature of order? You evict somebody and put a lock.
Whether the petitioner was there in the shop or not, whether he was in the possession of the
There
shop.
was a 144 proceeding between petitioner and a private respondent. What were you doing? Evicting somebody, favoring somebody. Who is this person who has passed this on? Then what happened in 145 proceeding? Was it converted or not converted? Then what happened?
The use annexure C of our counter page 35.
Where is the petitioner? Madam Chandana Kumari is absent. She sought time to seek instructions. You are for the intervener. What do you have to say? So? Intervention has been allowed. What is your stand in the intervention application? Regarding what? What is your claim? You are in possession of the property.
My husband was in possession of the shop and he has constructed that shop and the land in question was also in his
And they were in illegal possession. They were in possession or they were not in possession? Where is her right? Very good. Now there is they say that neither the petitioner nor the respondent number 4 were in possession of the property and it belongs to the intervener. A new story has come up. Why did you poke your nose and evict the petitioner? It's not your problem. No proceeding initiated. Where is Madam Chandana Kumari? बुलाइए जरा उनको. ऐसे हम नहीं तो हम DFD कर देंगे. Last date she had taken time. It was also observed that the case has become infructuous. Call her please. 1 बजे आएंगे.
Item 16 WPL 3425 of 2018.
Yes, petitioner.
So the last occasion the respondents took time to file a counter affidavit. But please to see the award that starts from page.
Counter affidavit for what purpose? Yes, why did you take time to file a counter affidavit?
Counter affidavit was with a new issue with respect to the whether the workman has worked for the 40 days or
That
this
is
a
the
new
only
issue out of the award that has not been raised before the court.
We will only see the records. We will not permit you to file anything more.
That is they have raised.
Para 26 of the award, without any basis, the learned court below gives a finding that they are working for 240 days.
Where is it?
Without Lordship, page 41, para 26. So that cannot be said to be a new issue. And the basis is they say, the learned court below says, the tribunal says that CMPF compliance was there and I-cards were issued. Also under Contract Labour Management Regulation and Abolition Act, whenever a contract employee is employed,
Lordship, our contractor signs the I-card, we countersign it. Otherwise, they will not get an entry. And CMPF Act, Your Lordship, itself covers all employees, including contractual employees. And as many as 22 persons have been directed to be regularized. Lordship, there is absolutely no evidence except ID card and Your Lordship's.
By way of camouflage system, the workman is working there, and the management is taking the work since the 1992
You see,
itself. And
just
the
a
award is
moment.
based on the basis
Just a moment. We do not want any statement from either of you which is not based on record. Right? Now he is placing the record award by saying that there is no finding. What do you have to say to that? There is no finding to the effect that you have worked. Is there any finding? You just show it.
No findings so far. It is the case of regularization.
Let us see the
It is the case of regularization.
Just a moment. 133 others is justified regularization.
Yes.
Right? Demand of
Yes.
regularization. So what
Till
is the
then they
condition?
are
Just a
doing the
moment.
work.
Please hold on. What is the condition precedent for regularization?
For the condition is minus the nature of the work, the condition, the situation of the work that should be considered on the points of the workman is concerned.
And number
the
of
work
days?
is perennial nature of work. It is the self-picking work. In consideration to the management, it is the category 1, which is the statutory directions has been on that point minus has been the category 1 has been
Come to page
considered.
number 34. Page 34.
Yes.
Right? One witness from each side.
Yes.
And documents of management marked exhibit M by 1 to M by 7 and documents of workmen marked at W1. Now let us see where is the discussion of the oral and documentary evidences.
From paragraph 17 onwards.
Read it please. Read it.
NW1, Bendik Ziklom, senior manager personnel, says in his cross-examination that there is no self-picker designations in the Kesargara railway siding. Self-picker are category 1 workmen. We use blasting to get coal. Coal are mixed with some jhama, etc. We are selling only coal to the parties by feeder breaker. Big coal pieces are brought to site. The WW1 Srimati Santi Devi says in his cross-examination that I have no appointment letter, but I can file the letter of Narula Sahib, an officer of the BCCL. We are getting wages from the BCCL. On perusal of the record, that out of 134 workmen, 28 workmen was died during the pendency of the reference case, whereas 67 workmen are alive and his names are filed on behalf of the concerning union. It means 106 are alive, but the rest names are not filed by the concerning union, were alive or dead. No comments filed by the concerning. 22 workmen out of 106 who are filed passbook of CMPA, which is marked as W1 series. On perusal of the passbook of CMPA, it is noticed that account number, address and deduction is mentioned on it. It is also noticed that the passbook issued by the project manager, block 2 area, who has signed and stamped on it, and photograph is also passed on it. They filed the photocopy and original, which is the compared and original returned to each of the workmen. Witness of the management being senior manager personnel stated in his cross-examination that it is a fact that self-picker work done by contractor by his laborers, contractor are engaged by us, but I do not know personally the concerned workmen or their work. It admitted by the management in his written statement that for maintenance of high quality of coal to certain kinds of consumer, the contractor is required to ensure loading of coal free from stone and cell, and in that connection, the contractor engaged few persons, but some of the persons appearing in the list annexed to the schedule of the reference has worked as contractor worker under the transport contractor. It is also admitted by the management that coal is processed at the colliery siding, where shell pickers are engaged to pick out shell and stone from the dump, and the coal with proper quality is transferred to the railway siding for the loading into wagon. On perusal of the document of workmen, there are many ID cards and pay slip have been filed. In pay slip in which it is mentioned that the main employer BCCL Block 2 area jail. The evidence of the management is very much material with perusing the evidence of.
You see para number 24, which document and relating to which workman?
Thereafter, there is only 22 out of 106.
No, para number, pause for para number. Two
Yes.
things are very, very
Yes,
clear.
yes.
One is, in one sentence, he is only talking about cross-examination of witness. There is no mention what was their case, in evidence in chief. No mention, correct? In para number 24, he says that on perusal of documents of workmen, there are many IDs. Which are those IDs? Which is concerning which workman? Not mentioned. Now you come to para number 20.
There are 25 more. The evidence of the management is very much material, where by perusing the evidence of MW1, is being senior manager personnel who said that workmen engaged through contractor for shell picking job is also admitted in his written statement. There are many identity cards filed in the case was signed by the management officer, though it was issued by contractor. It is clear-cut camouflage. While perusing the whole record, following 22 numbers workmen have ID card and passbook of the CMPF whose names is given. This workman has been considered on the points on their ID and the.
आगे पढ़िए 26.
On perusal of passbook of CMPF, it is issued and signed by the project manager, Block 2 area, Mrs. BCCL, and the photograph is also tally with the list of the workmen filed by the workmen previously long time ago. Hence, it is felt that the shell picking job is look like regular nature of job, and also felt that they were working continuously to 140 days in a year.
What is the material to say this? Is there any discussion?
On that point, so far the 40 days is concerned, my lords. Thereafter, what will it is a case of regular arrest. 40 days generally comes under the idea for the persons in respect of
Why
the
has he
retrenchment.
recorded this? You see, there are two aspects of the matter. One is that it is a perennial nature of work.
Yes.
Right?
Yes.
Second is that these persons were working continuously for 240 days. Right? Merely because the work is of perennial nature, that will not entitle these persons to be regularized. For the purposes of regularization, certain criteria is laid down and that is required to be satisfied. If there is a perennial nature of work and a person works for only one day in that work, will he be regularized? There has to be a specific finding that they have been working for so many years, continuously, not continuously, whatever is the period of work. Therefore, evidences have been led, the materials have not been considered properly. So it has to be remanded. And we are seeing many orders of Mr. Arkesh.
This is perhaps the lengthiest order which he has passed.
This is the lengthiest order he has passed. Otherwise, he passes 2 pages order.
I also understand, but the
I know,
scope of
you
the
will be-
workman is concerned.
You tell the date, you will fix the date, there is no problem on that. Now we have already
What's
passed an
happening
order.
nowadays, my lords, so far the
Only
CIT is
22
concerned at the
persons
time,
are
but it is not functioning for the last
No,
2 to 3
we have,
years.
I was adding to it. We have already passed an order that any person who is in charge is supposed to take up matters. He is not there only to pass adjournment. And the records are already complete. You tell me the date, we'll fix a date. Because there is no question of further evidence. Right? Whatever is there,
No, that can be considered on the
this
points
will
of
be
the
considered on whatever be the
Right.
point.
Exactly.
Is that okay? The learned counsel for the parties are present. WPL है. WPL 3425 of 2018. heard the learned counsel for the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the impugned award passed by the learned presiding officer, Central Government Industrial Tribunal number 1 Dhanbad, in reference case number 87 of 1995, is perverse in view of the fact that the award does not discuss the materials placed on record in totality. While considering the oral evidences, only 1 or 2 lines of cross-examination has been mentioned, and the examination in chief has not at all been considered. He has further submitted that while coming to a finding in para 26, the learned tribunal has held that shale picking job looked like regular nature of job, and it was also felt to the learned tribunal that the concerned workmen, total 22 in number, in whose favor the award has been passed, were working continuously 240 days in a year. And it was also felt that they were working continuously for 240 days in a year. The learned counsel submits that by coming to the aforesaid finding in paragraph 26, particularly with respect to continuous work of 240 days, there is no discussion in the entire award. He submits that the impugned award be set aside and matter be remitted back for fresh consideration, as the evidences, on the basis of evidences which were already filed before the learned tribunal. The learned counsel, appearing on behalf of the respondent workmen, respondent union, has opposed the prayer of the petitioner. However, during the course of hearing, he has not been able to show any material in the impugned award discussing the examination in chief of the witnesses, and further he has also not been able to show as to how and on what basis to show any deliberation of the learned labor court, learned tribunal, while coming to a finding that the 22 workmen had worked continuously for 2 months. Right? After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court is of the view that the learned tribunal, while passing the impugned award in connection with 22 workmen, has not considered the materials on record in totality. The examination in chief of the various witnesses have not at all been discussed, and there is no discussion with regard to the period of work, much less continuous period of 240 days. It further appears from the impugned award that relief was granted only in favor of 22 workmen, and so far as the remaining workmen are concerned, they are not aggrieved by the impugned award. Considering the totality of facts and circumstances of this case, this court finds that the impugned award is non-speaking in many aspects of the matter and suffers from non-consideration of materials on record. Accordingly, the impugned award is perverse and is hereby set aside, and the matter is remitted back to the Central Government Industrial Tribunal number 1 Dhanbad for passing a fresh award after taking into consideration the materials on record and after granting an opportunity of hearing to the learned counsel for the parties, to the respective parties, counsel to the respective parties. It will certainly be open to the respective parties to file their respective written notes of argument based on the materials already on record, such that there is no gap in the matter of deciding the case. There is no question of needing any fresh evidence, as the evidence has already been placed on record. It is further observed that the fresh adjudication will be only with respect to the 22 workmen in whose favour the award was passed. The parties to appear before the learned industrial tribunal on 25th of November, and upon their appearance,
in that time, most probably election is
okay, on 2nd of December.
25th counting there. Counting maybe there, that's why
23rd coalition. On the
13th.
2nd of December.
2nd December.
On 2nd of December, right? The parties to cooperate, let the fresh award be passed within a period of 3 months from 2nd of December 2024 without being influenced by any observation or finding recorded in the input. Record आया है इसका, ओरिजिनल है कि फोटोकॉपी है?
Tribunal वाला, there is no regular tribunal is going on.
आप देखिए ही नहीं, आपको यहाँ के ऑर्डर्स का पता ही नहीं है. For your information, this record is also there. You can just have a look, right? आप देख लीजिए इसमें ना, because ultimately it will for the settlement of written submission also, it will come to you only. You can just have a look at it. This will be in that, it will remain intact in the record. You can have a look at any time. Just photocopy of that.
Item 17, WPC 314 of 2019.
Yes, petitioner.
Lordship, in the present case, there was an inquiry that has to be conducted by the respondent number 4 as per
What
the
is
last
the prayer?
Prayer is for the quashing of quashing of notices dated 1/12/2018 respect of petitioner this 1 P and 8 and notice dated 27/2/2018.
Notice was stayed.
Still, Lordship, it was stayed.
Notice was stayed by this court. What is the order?
Last order was for conducting the inquiry with regard to the notices.
Forget about the inquiry. You just tell me. Where is the order of stay? Date? When was the stay order passed? There was already a proceeding under.
There was a proceeding going on in BA case and.
BA case? BA is what?
BA is Bihar premises land and tenant.
Okay, rent control.
So लॉर्डशिप इसमें बस एक सिंपल ये सबमिशन है कि इसमें एक बार जो इन्होंने सप्लीमेंट्री एफिडेविट सबमिट किया उसको एक बार देख लेंगे. The order under challenge, the notice under challenge has been considered erroneous by their officer only, and the
proceeding under BBC Act has been initiated.
Yes, it's going on.
So these notices will be has to be, both things can't go on. Who has filed the proceeding under BBC Act? JBC Act.
Second lot of litigation it is. First one is, can you see the page number 54 of the writ petition, madam? Earlier writ petition has been disposed of with direction
Yes,
to.
please hold on. On 13/2/24, when the case was taken up by a court, it was observed that these notices under Land Enforcement Act has been challenged and simultaneously proceeding for eviction under Jharkhand Building, Lease, Rent and Eviction Control Act has been initiated. Is it factually correct?
Yes, ma'am.
If it is factually correct, then the notices under Land Enforcement Act has to go. Because under the Jharkhand Building, Lease, Rent and Eviction Control Act, you can initiate a proceeding. It is a dispute between landlord and tenant. So there is a legal relationship between the two. Then where is the question of enforcement? Now you answer this.
Madam, can you see the page number 53 of the writ petition, 54 of finding earlier order, madam. Once it petition filed writ petition challenging the annexure 4 of the earlier writ petition, madam, court hold that the respondent should take appropriate action as per law. After that, madam, respondent number 4 issue a encroachment notice and
Pursuant to order passed by this court.
Yes,
Annexure 3.
kindly see the page number 54 of the writ petition. पिछला 10 साल से हमने ना तो रेंट पेमेंट कर रहे हैं, उस वो एक छोटा सा जगह है दसीडी के ठीक बगल में इंक्रोच किए हुए, वो इतना कंजेस्टेड जगह है, उसको तोड़ना है वो भी नहीं हो पा रहा, ना रेंट पेमेंट कर रहे हैं, जबकि ये डिसाइड हो चुका टाइटल में कि ये प्रॉपर्टी बोर्ड का है, बोर्ड ऑफ डिस्ट्रिक्ट बोर्ड का है।
आपके टेनेंट है?
जी, ये बोलते कि हम टेनेंट हैं, मेरे टेनेंट नहीं है, ये बोलते कि दूसरे जो जिससे मेरे साथ डिस्प्यूट हुआ था टाइटल को लेकर,
स्टेट
हम डिस्ट्रिक्ट बोर्ड है, जिला परिषद देवबंद, मेरे और जिनके बीच में पूरिया धर्मशाला उनके बीच में डिस्प्यूट था टाइटल, वो टाइटल डिसाइड हो गया मेरे फेवर में, ये पिछला ऑर्डर में आ गया। अब इनको जब एक तो 10 साल से टेनेंट से कभी पेमेंट नहीं कर रहे हैं, अब बात
ये टेनेंट किसके थे जो आपके साथ डिस्प्यूट डिसाइड हुआ?
ये बोल रहे थे उनके टेनेंट हैं, जिला परिषद के नहीं है।
दैट्स राइट।
टाइटल में मेरे फेवर में हो गया।
ठीक है, टाइटल होने से क्या हुआ? पोजीशन तो नहीं हुआ ना आपका?
पोजीशन नहीं।
यू हैव योर टाइटल हैज बीन डिसाइडेड विद टेनेंसी।
जी, जब मेरा टेनेंसी है वो एक जर्जर मकान है, एक तो रेंट भी पेमेंट नहीं करते हैं, पिछला बार लैंड इंक्रोचमेंट का ये केस हुआ, बिल्डिंग टेनेंट को देखा जाए तो पेज नंबर 55 में है एनेक्सर कोड, उसको चैलेंज किया, कोर्ट बोला कि एज पर लॉ आप प्रोसीड करिए और खाली कराइए। पिछला जो है बीए केस नंबर 1330
in annexure 3 what was their grievance? Which were the notices which were challenged?
Annexure 6.
Annexure 3 first.
एक तो 91 से रेंट बकाया है, वो रेंट भी नहीं दे रहे हैं, उसको खाली भी नहीं कर रहे हैं। इंक्रोचमेंट का केस करते तो बोलते इंक्रोचमेंट नहीं चलेगा, बिल्डिंग एविक्शन का केस करते तो बोलते वो भी नहीं चलेगा।
कहाँ लिखा है कि बिल्डिंग एविक्शन का केस नहीं चलेगा? आप उनको बताइए एनेक्शन 3 में जो नोटिसेस थे, मेमो नंबर 67, 68, 70, 72 एंड 74, where are these notices?
उसी को पिछला रिट में चैलेंज किया गया था।
That was under what provision? BBC Act or under enforcement?
BBC Act।
From where do I get this?
Annexure 4 में पेज नंबर 54 55 Annexure 4 पेज नंबर 55 BA केस नंबर 1330।
BA case is what? I've never heard of BA case under JBC Act. बताइए। अतिक्रमणकारी फर्जी, ये तो अतिक्रमणकारी का प्रोसीजर। फिर that was a proceeding under encroachment. Who Who has filed the BBC Act cases? Which are the notices annexed along with it? Yes, Counsel, which are the notices annexed? You say that BBC Act proceedings have been initiated.
Yes.
Where are the notices?
Yes.
Tell us where are the notices?
Notices are not part of this.
Is there any order?
Order is there in page number 55 onwards.
You see, there was a specific order passed by this court on 13/2/2020. Right? You had submitted for the same property, the notices were issued, and there is a proceeding under JBC Act. Which is that document to show that the proceeding under JBC Act is pending?
Just one inquiry, one submission is there that they have, when respondent number 4 has said that this notice are erroneous, and they have initiated the action also against the concerned circle officer. So if we'll go through that affidavit that they have submitted, they have accepted that there is no document with regard to the notices that they have issued.
13/2/2024. It is an uploaded order.
13/2/2020.
Read it. Read your submission para number 2.
The Credit Counsel petitioner submits that in respect of the same property in question, for which the instant notices were issued, the respondent have already filed the proceeding under Jharkhand Building Lease and Rent and Eviction Control Act. As per him, when the proceeding was already initiated under Jharkhand Building Lease, Rent and Eviction Control Act, a parallel proceeding under Public Land Encroachment Act is not maintained.
Yes. So where is that proceeding? You were granted time to bring it on record. Show me from the record. As simple as that. We'll quash the encroachment notices and ask you to participate and ask them to decide it expeditiously. Tell us.
Short password.
What passover? Where is the affidavit in pursuant to this 13/2/2024? You had made oral submissions, maybe on instructions.
Lordship, there is a supplementary affidavit that has been filed on copy of same is
27/2/24.
27/11/2024. It's in regard to the same. We have filed.
Where is the notice under BBC Act?
It's annexure S2. Page number 9 of my supplementary affidavit.
Yes, Steve.
On the last bill, there was a direction, my lord, with respect to the initiation of or sending notice under JPLE Act. For that, my lord, we have my lord, Jharkhand Public Land Encroachment Act, my lord, section 3, my lord, the notices have been issued, my lord, and my lord, and thereafter, my lord, the coordinate bench of the Supreme Court has directed the state to, my lord, conduct an inquiry, my lord, and we have filed a supplementary affidavit, my lord, that indeed the notices were issued, my lord, under JPLE Act, my lord, but since the records were not found, my lord, and therefore, my lord, against the hearing circle officer, my lord, we have initiated, my lord, we have directed the Deputy Commissioner to initiate a matter.
Which records were not found?
My lord, the record of, my lord, that JPLE section 3 notices, my lord, by which the, my lord, JPLE proceeding has been initiated, my lord. We have given a specific statement matlab in supplementary counter affidavit matlab paragraph 6.
We don't bother about it. You just tell us they are encroacher or they are your tenant.
No, matlab they are encroacher matlab.
Then why have you initiated this proceeding?
They have agreed that this.
Why have you initiated this proceeding? Annexure this 10. This notice issued in BA case number 13 of 2013.
That has been perhaps initiated by the district board matters. As the land belongs to the district board matters. When we have stated in our counter affidavit.
ये जरा इसका रिकॉर्ड नंबर WPC number 5317 of 2004. There is the Annexure 7 series of the earlier petition which the court has refused to interfere with. Once there is a refusal to interfere with certain notices by an order of this court, they are bound to proceed under those notices. If it is under land encroachment, they will proceed under land encroachment. If it is under BBC Act, they will proceed under BNS. यही बोलना चाह रहे हैं।
वही हम बोलना चाह रहे हैं, या तो ये टेनेंट है या तो ये इंक्रोचर है। दोनों में से
इसका रिकॉर्ड मंगाइए जरा। WPC नंबर 531 just a moment. WPC number 5313 of 2004 decided on 26/10/2016. है क्या साथ में?
Yes.
91 से रेंट भी नहीं दे रहे हैं।
कोई बात नहीं। You just have a look at this annexure 3. The notices which were impugned in that proceeding, the court has refused to interfere. Right? So they are bound to proceed as per those notices. Right? Now let us see that what by those notices. It only says that in 3 days' time, you evict the premises, failing which appropriate action will be taken to remove you from the premises.
Lordship, they have initiated BA case number, district.
They have not initiated. They have stated that as to why a proceeding be not initiated. Have they
Lordship,
initiated?
they have the BA case number 13/2013 is going on. Vikas Upayukt सह मुख्य कार्यपालक अधिकारी जिला परिषद देवघर. They have initiated.
It is not a proceeding under JVCJ.
This is BA case. This is earlier it was governed by Bihar
Building Lease Rent and Control Act.
Lordship. So
Now,
they have initiated.
Now this proceeding is going on before which authority?
अदालत अनुमंडल दंडाकारी देवघर.
Judicial magistrate. Isn't it?
Okay. So it's going on.
And what is the present status of this proceeding? What is the present status of this proceeding?
Present status.
अप्लाई नहीं करते
अभी से अभी appearance का date fix है.
I'll
No, you don't need to.
I'll
It's
take
a-
the
it's a-
instruction from.
No instruction required. It's a very recent affidavit. And you say it is pending. We'll fix a date from here. ठीक है? Right? We'll fix a date from here, you decide it. They'll file, the matter should be concluded within a period of 2 months from the date fixed by this court.
But once, I mean, like, what should the
That's 2013, the matter is pending. How many years? 10 years.
short Passover
No
may be given,
Passover.
my senior will be.
No Passover. लिखिए. WPC number 314 of 2019. Heard the learned counsel for the parties. This writ petition has been filed for the following relief. An order dated 13/2/2024 was passed by this court, which is quoted as under. From the perusal of the enforced order, it is apparent that the specific grievance of the petitioner was that the proceedings under Jharkhand Public Land Enforcement Act could not have been initiated on account of pendency of proceeding under Jharkhand Building (Lease, Rent and Eviction (Control) Act. And therefore, there could not be parallel proceedings under Jharkhand Building, Lease, Rent and Eviction Control Act and simultaneously under Public Land Enforcement Act. A supplementary affidavit has been filed by the petitioners in this case pursuant to order dated 13/2024 mentioning that the case mentioning that giving the details of the cases with regard to the proceeding under Jharkhand Building, Lease, Rent and Eviction Control Act. The details are as follows. इसको एकदम कोट कर दीजिएगा पैरा नंबर 4 से. There are different cases or it is one case?
It's just one case.
Sorry?
Again, there are multiple cases against, there are multiple encroacher as per them.
Encroacher. We are only bothered about the petitioners here. You are party in which case? BA number
313.
BA case number 13 of 2013.
2020.
That is the only case in which you are party.
Yes, yes.
The check करिए. Page number 10 and name of the petitioner. Yes, annexure at page 10, your name is not tallying. Yes?
Page.
The name of the petitioner does not tally with annexure 10, page number 10 of supplementary affidavit.
Yes.
Substitution.
Yes? Only one person. What about others? There is another BA case wherein notice has been issued. The petitioner has annexed notice issued by the sub-divisional officer cum rent controller Devswar dated 28/9/2013 in BA case number 13 of 2013 and dated 12/12/2013 in BA case number 13 of 2013. Name of the addressee of the notices are as under. ये सबका नाम दे दीजिए. बताइए इसमें से कोई ऐसा है जो पिटिशनर है और यहाँ पर नहीं है? Mantu Ram Mohri is there.
Lakshmi Devi is there.
Madan Ram Mohri.
Madan Ram Mohri is there. Petition number 2.
Lakshmi Devi.
Lakshmi Devi is there.
Okay, Lakshmi Devi is there. Narendra Kumar Singh. नरेंद्र कुमार सिंह तो नहीं है, नहीं है ना? चंद्रशेखर दुबे,
चंद्रशेखर
नहीं है.
Madam, that has been substituted. That might be substituted because in serial 8, madam, there is Radhe Shyam Dubey, madam. And Radhe Shyam Dubey is the madam, son. Chandrasekhar Dubey is the son of Radhe Shyam Dubey.
राधे श्याम दुबे का नाम है?
Madam, serial 8 in madam page 10. Supplementary.
8 राधे श्याम. ये तो चंद्रशेखर दुबे son of. What about Narendra Kumar Singh? His father's name is Nipu Singh. No, son of late Ram Charan Singh. Is there anybody called Ram Charan Singh?
serial 7 में नीपू सिंह पिता राम शरण सिंह.
7.
And Sukhdev Ram.
Sukhdev Ram, Baldev Babulal, serial 9.
Babulal Ram.
Serial 9.
Rajesh Ram. Okay. In the name of these persons, counsel for the petitioner submits that a few of the petitioners involved in the present case are son of the persons to whom the notice was issued in BA case number 13 of 2013, and upon their death they have filed a writ petition. He has submitted that the said proceedings are still pending. The learned counsel appearing on behalf of the respondents. Respondent number आप किसकी तरफ से हैं? Respondent number 2 has submitted that in WPC number 5313 of 2004 dated 26/10/2016, a number of notices were challenged bearing memo number 67, 68, 70, 72, 74, all dated 24th of June 2004, wherein the petitioners were asked to vacate the premises within a period of 3 days and shops were to be constructed. He submits that this court did not interfere with the notices. And also recorded a submission that the respondent board had submitted that step for eviction of the petitioner would obviously be taken in accordance with that. The learned counsel submits that the proceedings which have been initiated by virtue of BA case number 13 of 2013 is not proceeding in view of non-cooperation by the petitioners. However, no such affidavit has been placed on record. The fact remains that as per the affidavit dated 27/2/2024, the proceedings are pending. Considering the aforesaid facts and circumstances of this case, this court finds that the petitioner has brought on record the proceeding which has been initiated against the petitioners or their predecessor in interest by virtue of BA case number 13 of 2013 under the provisions of Jharkhand Building (Lease, Rent and Eviction (Control) Act. But the same is still pending. Apparently, more than 10 years have elapsed. This court is of the view that the respondents cannot initiate both the proceedings with respect to the same premises, one under removal of encroachment under under Jharkhand Public Land Enforcement Act 1956, and also for eviction of the premises under the provisions of Jharkhand Building, Lease, Rent and Eviction Control Act. Certainly, if one or the other person is in possession of any property over and above the premises involved in the BA case number 13 of 2013, इसलिए इसका मत लिखिए ना, वो आप केस ही बनाएं. In such circumstances, the impugned notices which has been issued by the respondent number 3, dated 15/2/2017, as contained in initial 5 series under the provisions of Jharkhand Public Land Enforcement Act 1956, cannot be sustained in the eyes of law, and accordingly the same are set aside. However, at the same time, the proceeding initiated under Bihar Building Lease, Rent and Eviction Control Act 2001 है ना? 1982 as mentioned in the under the Jharkhand Building Lease, Rent and Eviction Control Act cannot remain pending for an indefinite period of time. And no reason has been mentioned in the supplementary affidavit with regard to such pendency. Consequently, the subdivisional officer cum rent controller Devgar is consequently the petitioners are directed to appear before the subdivisional officer cum rent controller Devgar on, बताइए कब appear करेंगे? 12th of November?
12th.
Right? On 12th of November 2024 at 11 a.m. petitioners and
12 नवंबर नहीं किया, इलेक्शन है उस दिन एसडीओ को काम है.
बताइए कब करें?
उसके बाद 20 के बाद करेंगे.
20 के बाद, हाँ?
23 के
बाद. On 26th of November. Petitioner and आप appear होंगे? हम तो and the respondent number 2 or his authorized representative. Upon their appearance, the the aforesaid authority shall ensure expeditious disposal of the pending proceedings, and the final order be passed as expeditiously as possible, but not later than 3 months from the date of their appearance. In case there is any difficulty in complying with this order in letter and spirit, it will be open to the parties to seek extension of time by filing appropriate petition in this proceedings. By filing another CMP. यहीं से extension होगा।
तो रेंट 19(1) से ड्यू है।
वो
उसको डिपॉजिट करने का
वो सब कोई ऑर्डर नहीं है। आप तो सब इधर से उधर घूमते भटकते रहते हैं।
Pass over case item 13 WPC 50026.
Give your appearance, please. Yes, petitioner. Yes. You are seeking disposal of your representation.
Yes, petition, but the only thing is that one judgment of petition was given to me that this can be disposed of in terms of section 3H. It cannot be, because the land has never went for acquisition. My case is entirely
This was never subject matter of acquisition.
This is my case. When the acquisition lots were mentioned, it was not there. It was not there, it has never went. Why? Because behind the back, the state probably has said to the authority that it is government land. How it is a government land?
So therefore, if there is any dispute, whether there is, the fact remains that even for the state they have to pay, right?
Yes.
They have to pay compensation
Yes.
even to the state.
Yes.
Now the state has declared that it is their land.
But whether the
Please hold
state
on,
can
please,
declare.
just a moment, please hold on for a moment. State has declared, rightly, wrongly or whatever, that it is their land, they handed it over to them and then took money. Now there is a dispute whether it is your land or whether it is a land of the state. Right? This will be decided only under section 3.
If prima facie I can establish before the court.
No, not in this court. You cannot establish it. We will not.
Another aspect is
What another
whether the
aspect?
state being custodian of record can create parallel
We do
document.
not know. We do not know whether they can, they cannot. They can certainly, if there is no dispute, they can hand over their land to them. We do not know what is happening.
Despite the order of this
The
honorable
fact
court, no
remains, you
affidavit
see,
was.
you want compensation if it is to be acquired?
Yes.
You will get it only through a competent court. Because they will not give you compensation twice. Once to the state and once to you. Right? So ultimately what is going to happen? The compensation given by the state is to be given to you on whatever fair rent basis or whatever. Right? There will be two disputes. Whether you will be entitled to compensation or the state will be entitled to compensation. The second would be what? The quantum of compensation.
Yes.
So that has to be decided by a competent court. Because even the quantum of compensation is to be decided by a competent court. Disposal of representation is not going to serve your
But the
purpose.
question is when the land itself is not being acquired, then.
No, they have.
But that is not on record. Today, leadership is asking me to approach the authorities. It is not within this notification.
So if it is not there, if it is not the land which has been acquired, they will consider your representation. Simple.
I highly appreciate that at that point of time the rights become remediless. Then the only remedy will be left over.
You say that your land has not been acquired.
I say that this notification which was issued in terms of particular khatas, plots, etc., that does not contain my
Very good.
plot.
They're very good. So simple.
The question is whether a person can be deprived from its property without acquisition process.
That also, you see.
But that the
loca-
Honorable Supreme Court says can't.
Just a moment. What is the location of your property? Where is your property situated? Whether you are living on that particular property, these are essentially subject matter of consideration by the civil court. Writ court cannot decide it. And your prayer is for disposal of representation, I'll ask them to dispose of representation. I will not go anything further. Why should we? This is a very short prayer you have made. I'll ask them to dispose. Who is before whom they have filed a representation?
District land.
Well, you go and get your representation disposed. We will not say anything. Beyond the relief, we are not going to give you any prayer. Okay, heard the learned counsel for the party. The learned district petition has been filed for the following relief. The learned counsel for the petitioner submits that the petitioner has raised objection in connection with notification dated 7th of April 2015 in connection with acquisition of land pertaining to plot number 985 under Khata number 6. In connection with the property mentioned in the prayer portion of the writ petition, but the representation has not yet been disposed of. The learned counsel has submitted that as per the writ record, the acquired land does not contain the land of the petitioner, right? But the petitioner has been dispossessed?
Yes, dispossessed land is taken over by.
Okay, but the petitioner has been dispossessed from the land. He has submitted that the learned counsel appearing on behalf of the respondent number 3 has submitted that the land in question was handed over to respondent number 3 by the state government by declaring the property to be the property of the state, and the formalities were completed. She has submitted that road has already been constructed on the said property. The learned counsel has also submitted that the dispute in connection with right, title, interest, possession, compensation, etc. with regard to the same has to be adjudicated in terms of section 3H with bracket 4 of National Highway Act 1956. She has relied upon orders passed by this court in WPC number 5082 of 2017 and WPC number 1832 of 2017. The learned counsel appearing on behalf of the state has submitted that the petitioner has made a simple prayer for disposal of representation. The grievance of the petitioner can be looked into, and if the land of the petitioner has not been acquired, the petitioner may not have any grievance. He has also submitted that physical location of the land being claimed by the petitioner is also required to be verified with respect to the description of property which has been mentioned in the acquisition of land. After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances and the nature of relief as prayed for by the petitioner in this petition, this court finds that this court hereby directs the respondent number 2 to consider the representation dated 4/9/2015 filed by the petitioner while considering and pass a reasoned order after granting an opportunity of hearing to the petitioner as well as to the respondent number 1 and 3. Intervenant one. Respondent number 1 and 3 and also the intervener, namely, बताइए.
IA number 8416, order dated 2nd of September 24. On behalf of Badal Mehta, Vijay Kumar Mehta, Chini Prakash Mehta, अशोक आइए हमारा है वो आइए
या आपने इंटरवीनर्स का नाम कॉस्ट आइटम में नहीं डाला है, वो कौन करेगा? कॉस्ट आइटम में रहेगा तो हो ही जाएगा ना.
Office is directed to correct the replace the paid media amended for order में paragraph 7.
Corrected after intervener petitioners कहाँ है इसमें? इंसर्ट नहीं किया है.
paragraph 7 में है rule call 2nd September 2024.
Amended cost item. Corrected.
Petitioner was directed to file a fresh copy of all the title, adding the interveners and party responded within 2 weeks.
Did you comply it? Where is that? Including the intervener petitioners whose intervention was allowed by IA number 8416 by order dated 2nd of September 2024 being IA number 8416 of 2022.
My only request,
In
paragraph
the-
5 may be seen on same order. It is hereby clarified this addition of parties.
No, they will just hear them. There is no creation of any right in your favor, in favor of either parties.
That my lord,
Yes.
be recorded.
Yes. At this counsel for the petitioner has submitted that it was clarified in order dated 2nd of September 2024 that addition of party through the interlocutory application will not create any right in favor of the interveners. All the aspects of the matter will be duly considered by the respondent number 2 while considering the representation. And the parties to appear before the respondent number 2 on बताइए डेट बताइए कब appear होंगे?
Third week of November.
Okay. On 25th of November 24 at 11 a.m. The respondent number 2 is directed to pass a recent order after granting opportunity of hearing to all the concerned parties and if required measurement तो नहीं कराते हैं, वो दिक्कत हो जाएगा, उसमें दिक्कत है. The reason order be communicated to the concerned parties to speak first. The reason be done within a period of 1 month from the date of appearance.
The parties will appear along with the order of this court.
Along with the order of this court and also the writ records. Writ ये रहता ही. Record pass over.
Item 15 WPC 7030 of 2017.
Yes, petitioner. Yes, madam. We were looking for you. You have any instructions?
My shop, yes, sir. अभी भी shop बंद ही है. Locked.
Locked.
Yes, sir. We are paying for the.
To unlock the shop.
Yes, sir. There is one.
You are not-
The lock has not been put by us. We have denied this fact.
Who has put the lock?
Respondent number 4 locks. The police in charge. Officer in charge Chakrabarti.
Respondent number 4. Who is representing respondent number 4?
We are representing, but your leadership, it has been stated by them in para 9 that it is respondent number 5 who has.
No, respondent number 5 is a private party. Respondent number 2 is a order.
Show us where is your statement that respondent number 4 has locked the premises.
Leadership, there's no record record also, no document to show that it was the law.
But Lordship, there is an order in annexure. In counter affidavit, Lordship also.
आप जरा देखिए ना पैरा 15 तक. You read your para 15. How is it worded?
That stated after the order passed by the learned subdivisional magistrate in the case number so and so, wherein the notice was directed to serve upon the petitioner and respondent number 5. Although the respondent number 4, without taking into consideration, no order has been passed by respondent number 2 with regard to put a lock over the shop premises. Petitioner, since then the shop premises petitioner has been kept locked.
क्या लिखे हैं कि respondent number 4 has directed to be served upon the petitioner and the respondent number 5 through respondent number 4 without आपका sentence से लग रहा है respondent number 5 has put the lock. You just read it. Maybe whatever you meant, but this is
But
what
the
it is
respondent
meaning.
number 5 is a private respondent number. They have made an application before the respondent number 2. That application has been registered in the Lordship, and that on that case, one order has been passed in 10/11/2017. In the 144 proceeding has been issued, and that the reason, and both parties have notices has been issued. Lordship. At that point, respondent number 4 has locked up my shop. Bus. That's it.
It is not appearing from your para 15. You read it slowly. It is stated. Read it, please.
That stated that after the order passed by the learned subdivisional magistrate in the miscellaneous case number so and so 10/11/2017, when the notice was directed to serve upon the petitioner and respondent number 5. Petitioner is the person. Respondent number 5 is okay. Through the respondent number 4, without taking into consideration that no order has been passed by the respondent number 2. With regard to put a lock over the show premises of the petitioner and since the show premises of the petitioner has been kept.
Who has locked it?
Respondent number 2.
No, it is not appearing from this statement. This miscellaneous case number 54 of 2017 has been decided finally?
No, Lord.
It is pending?
Yes.
Before whom it is pending?
Respondent number 2, Lordship, and the respondent number 2 is a subdivisional officer, Lordship.
It was converted into 145?
Till date, no order has been passed.
Yes, so Eviction, it has been converted, our annexed receipt, and the files have been forwarded to the concerned court also. Page 36.
No order has been passed. Till date.
Page number?
Page 36.
In
35 is the relevant part, Your Ladyship.
This happened on
proceeding has been
this
converted.
happened on 8/12/17.
Yes, Your Ladyship. Proceedings were converted 145 and the concerned records were
That
sent
is
to
after the passing of this order. After the filing of the report.
Yes, after the
It has been converted into 145
But
proceedings.
till date, no order has been passed.
Okay,
no.
just a moment, please hold on. It was converted. What happened thereafter?
No order.
Thereafter, what happened? 145 proceedings must have come to an end. Where is the final order?
Your Ladyship, we have the counter that we have filed, we have mentioned that the records were then sent to the concerned court.
Why? 145, wherever it is 145 proceeding has to come to a final conclusion by passing an order under 145. Where is that? Concerned court means what? Which concerned court?
Your Ladyship,
where have you stated?
Your Ladyship, page 36 only, it is part of the order.
Yes.
निबंधक व्यवहार न्यायालय चाईबासा के पत्रांक सो दिनांक सो के आलोक में मूल अभिलेख सत्र न्यायालय
They must have challenged this order.
के पास भी है.
They must have challenged this order. So this proceeding has to be concluded. 145. No, nothing. We don't bother about it. You are not. No. This 145 proceeding has to be concluded. You conclude this proceeding.
If it has not been concluded.
Yes, if it has not been concluded so far, you conclude it. बताइए कितना दिन में conclude करा दें? ताला खुल जाएगा एक महीना में.
Yes, we are ready for
You are also ready. You are for whom? Intervener. Who are you? Who is the private respondent?
Your Lordship, private respondent is respondent number 5, Your Lordship. In
Yes.
this case, we have received wakalatnama yesterday.
On
behalf
but
of
ये कहानी आप हम ना आधा घंटा सुनने के बाद हम नहीं सुनेंगे ये कहानी आपका, okay? Don't tell me these stories after half an hour. We will not. Who are you? Intervener. What locus do you have?
Your Lordship, the shop in question was under the name of my husband, Your Lordship.
You see, you have an independent right. We don't bother about it. Now, this proceeding under section 145 has to be taken to a logical end. Simple. Nothing more and nothing less. That should be sufficient.
I'm responding to number 6. Question of title and petition that has to be decided with the court of complete jurisdiction.
145.
145 basically started with right to possession.
Yes.
Then it was referred under 145. That court will look into who is having possession on what basis.
That authority.
That
145 has to be decided by an authority.
Competent
That
authority.
order might have been challenged before another court, and that is why the records were sent over there. And then वहाँ पे जो चल रहा होगा वो तो हम लोग नहीं जानते, but we will ask them to
Yes, my
confirm.
lord, the
So,
145.
order also that criminal revision में कहीं कोई stay नहीं है, so we are proceeding with this order.
Where is it?
145 proceeding.
Annex C, your leadership. Page 35.
Okay. Some criminal revision was filed.
Yes, your leadership. And since there तब कोई stay order का कोई direction draft नहीं है.
What was the criminal revision number?
That number is not given here.
Okay, anyways, it is recorded that there is no stay.
Yes, right.
Okay. Heard the learned counsel appearing on behalf of the parties, this petition has been filed for the following relief. The learned counsel for the petitioner submits that by referring to para 15 of the petition has submitted that the learned subdivision magistrate had instituted mysterious case number 54 of 2017 on 11/10/2017 and notices were issued to the petitioner and the private respondent. Yes.
Leadership in para 16 with one encroachment proceeding has been initiated lordship in the year of 1998 lordship in the honorable court CWJC of 3448 of 1990 along with other person honorable court has dated to 21/12/1990 had passed the interim order dated the proceeding in
We don't bother about it. 144, 145 is basically possession.
Yes, but
Simple.
we have a position in 1998 law.
We do not know. Has referred to mysterious case number 54 of आप लिखिए ना इसको. The learned counsel submits that a proceeding under section 144 was initiated by the respondent number 2 and no such order was passed to lock the premises. Still the premises of the petitioner has been locked. She has also submitted that the impugned action of locking the premises was undertaken at the instance of but was done by respondent number 4. The learned counsel appearing on behalf of the state has submitted that a specific counter affidavit has been filed in which it has been specifically mentioned that the respondent number 4 did not lock the premises. Correct?
ये answering respondents.
Answering respondents means
Respondent number 2 your leadership.
respondent number 2.
Has never ordered for locking of the said premises.
The
Para 16.
The learned counsel has referred to para 16 of the counter affidavit to submit that the respondent number 2 had never ordered for locking of the premises. She has submitted that the proceeding under section 144 CRPC was converted into a proceeding under section 145 by order annexed with the counter affidavit as contained in Annexure C. And since there was no stay order from any court, it was decided to proceed. The learned counsel has further submitted that the subsequent order dated 12/12/2017 reveals that the records were transmitted to the court of Learned Sessions Judge Chaibasa by letter number 105 dated 8/12/2017. She has also submitted that she does not have the present status of the proceeding under section 145. The learned counsel has further submitted that if the proceedings have not been concluded, appropriate direction can be passed so that the dispute is ultimately resolved. The learned counsel appearing on behalf of the intervener has submitted that the property actually belongs to the intervener. Correct?
And it was registered in the name of her husband.
And the property was registered in the name of her husband. However, the intervener is not a party in the proceeding under section 144 and 145 of CRPC. Correct?
Yes.
After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that although the counsel for the petitioner has referred to paragraph 15 of the petition to say that the respondent number 4 has logged the premises, but there is no further material on record to support such a statement. Further, the counter affidavit does not dispute the fact that the premises is locked. Correct? The fact remains that a proceeding under section 144 was initiated, which has now been converted into a proceeding under section 145 of CRPC. This court is of the considered view as back as on and the counter affidavit, and this fact has been brought to the notice of this court by the counter affidavit of the state filed way back on 5/3/2019. This court is of the view that entire matter can be resolved if the proceeding under section 145 is directed to be concluded, if not already concluded. It is further not clear from the record as to why the records were sent to the court of Learned Sessions Judge Chaibasa. But at the same time, the order dated 8/12/2017 revealed that there was no interim order passed in criminal revision. The number of the criminal revision has not been mentioned. no interim order has been placed on record with regard to the proceeding under section 145 of CRPC. In view of the aforesaid facts and circumstances, this court directs the respondent number 2 to conclude the proceedings under section 145 of CRPC, which is said, if not already concluded, the petitioner to appear before the respondent number 2 on 12th of November 24, and respondent number 5 has not appeared. In spite of service of notice, the respondent number 5 has not entered appearance. Sorry?
My appearance on behalf of respondent number 5 may be.
You have Wakalatnama?
Yes,
Okay. At this, MS number Khushbu Kumari has prayed to file, had submitted that she is already in possession of Wakalatnama on behalf of respondent number 5. She may be permitted to file the same during the day, during the course of the day. Permission is accorded. Upar hi rahega, theek hai? The petitioner as well as the respondent number 5 are directed to appear on 12th of November at 11 a.m. before the respondent number 2, and upon their appearance, the respondent number 2 shall pass appropriate order in the proceedings under section 145 of CRTC, so that the matter is taken to a logical end. A final order has already been passed, no fresh order need be passed. A copy of the final order be handed over to the respective parties. That's all. वो hearing वेरी का कर देंगे. No. Respondent, because it has been recorded there is no stay order. If there is any legal impediment, there is no stay order, as simple as that. It must have been concluded by now. This petition is accordingly disposed of.